Good morning. This is the February 10th, 2014 meeting of the Tennessee Real Estate Appraiser Commission. We'll begin with the roll call, beginning at my left. Please state your name and where you're from.
Gary Standifer, Franklin.
Norman Hall, Brentwood.
Michael Green, Johnson City.
Nancy Point, Rogersville.
Rosie Johnson, Paris.
Eric Collinsworth, Arrington.
Thank you. This regularly scheduled meeting of the Tennessee Commission is taking place in the first floor conference room of the Davy Crockett Tower at 500 James Robertson Parkway, Nashville, Tennessee. And notice of this commission meeting was posted on the TREC website on January 24, 2014. Is there a motion to adopt today's agenda?
So moved.
I second.
We have a motion and a second. Any discussion? Hearing none. Yes, Ms. Avers. Okay, so is that when we'll hear the entire legal report, or is this just a an amendment?
Just a short amendment to.
Okay, all right. We have a motion and a second. Would you all like to amend your motions or withdraw them?
I withdraw my second.
I'll withdraw.
Okay. So is there a motion to accept the changed agenda for today?
Second.
A motion and a second. Is there discussion? Hearing none. All those in favor of accepting the amended agenda, please say aye.
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 Any opposed? Motion passes. All right. Therefore, Mr. Joseph?
Mr. Chairman, I have presented to you all a supplemental legal report for today's meeting. I want to give you all an opportunity to go through it. It's probably just been put before you because I just finished it this weekend, and I did not have an opportunity to get it to you before the deadline for printing these on the iPads and emailing to you. So if the commission would like to take a few minutes and read through it and let me know when you're ready,
Thank you, sir.
I'll be ready.
Thank you. Let's take a few minutes then, if you will. The commissioners had a chance to review Mr. Joseph's communication thoroughly. Okay. If you'd like to proceed.
Thank you, Mr. Chairman, members of the commission. I have three matters before you today on this supplemental legal report. These are all matters that are presently in litigation or that have pending notices of hearings and charges. The first matter, of course, as I indicate, this matter has been presented to you all and represented several times. The bulleted allegations of the state's reviewer are before you, and of course they are that the reporting option was not prominently stated under SR 2-2. The definition of market value that the respondent uses was the definition that was set out in Advisory Opinion 22 of USPAP and was not the specific market value definition that's included in the TDOT guidelines for appraisers, which of course include or incorporate the language from the Tennessee Pattern Jury Instruction Civil 11.03, that the respondent did not provide any specific legal descriptions, plats, or other specific information, that he generally did not support his sales comparison approach and did not adequately complete it, and that he did not adequately complete his reconciliation. The respondent has responded to the results of this review, and of course he contends generally that his report was complete and met the specific needs of the client. In response to the bulleted allegations, the respondent indicated that he did use proper terminology. He included the specific term summary in describing his report, and that was sufficient under Standard Rule 2-2. That the definition of market value he used from Advisory Opinion 22 included all of the elements of market value that are included in the TDOT guidelines, that the trial judge in the condemnation case could have instructed him to use a different definition of value, and that any event the value definition which he used did not have the potential to mislead. Of course, he also contends that he identified the subject parcels by tax map reference, street names, right-of-way, and photographs, which he contends was sufficient identification. He claims that his sales comparison approach was adequate for the purposes of his assignment. Within the transcript of the condemnation trial, which, by the way, the respondent's client prevailed in, it did appear that he provided considerable support, analysis, and explanation for his conclusions in the sales comparison approach. Of course, as we have stated in this summary, This matter has been pending as a formal proceeding for about half a year. Both parties, on behalf of the state and the respondent, we have both aggressively litigated and continue to aggressively litigate this matter during discovery, which has taken place and still is outgoing or outstanding to a certain extent. Both sides have retained experts, and of course this would be a lengthy hearing if it goes to hearing. Neither party, notwithstanding the recommendation that's being made today, acquiesces in any suggestion that its respective case was weak. As litigation counsel, having tried many cases before this commission, however, I realize that the results of any particular hearing are speculative, and one does not know what the outcome may be. Based on those experiences and also based upon the outcomes of prior hearings and based upon a review of the entirety of the respondent's submission, the submissions of the respondent's expert, and the record as a whole as it stands now, I take into consideration the fact that the respondent has been certified as a certified general appraiser for 17, it's probably closer to 18 years now with no prior discipline, that there was no intentionally misleading conduct, and taking also into consideration the respondent's demonstrated expertise in other matters as set forth in the report. I believe that this matter could be appropriately handled by issuance of a letter of instruction for first-time infractions of the scope of work rule, problem identification section, because he did not set out clearly the proper definition of value in a condemnation appraisal involving TDOT, and for failing to support all of his analysis and conclusions in the sales comparison approach in the report or work file. I don't believe that the respondent will have problems of this nature in the future with the commission, and based upon the entirety of what you have before you, as well as the state of the current litigation in this matter, I would respectfully request the commission to authorize the closure of this matter with a letter of instruction, which would enable the state to close this formal proceeding.
Thank you, Mr. Joseph. So commissioners have heard the state's request, basically authorizing a letter of instruction. Is there a motion regarding this request?
Pardon me, Mr. Chairman,
Yes, sir.
may we address questions to the attorney?
Absolutely. Yeah.
Curious as to the context of the statement that was, quoting from the report here, respondent has responded to the results of the review and contends generally that his report was complete and reflected the specific needs of the client. That wording troubles me, specifically because if I understand this case, what little I do know about it, which is zilch, what we have here is an appraiser who evidently testified for a property owner, and evidently the state of Tennessee felt that his testimony violated USPAP and therefore filed a formal complaint. Is that generally correct?
Well, not generally correct, Mr.
Okay.
Chairman.
Thank you for the promotion.
Without providing further information which could taint this panel and taint this commission, and understanding that the role of the commission is to adjudicate and really not investigate in as much as getting into detail as to what the proof may be. The nature of the complaint in this matter is similar to the nature of the complaints in many other matters. The complainant, of course, complainants generally do not cite any alleged violation of USPAP. The complainants cite issues that occurred in either the underlying litigation or the problems had with the appraiser's work, but not necessarily USPAP. The allegations of possible infractions of USPAP come from the results of the review and not from the complainant.
Question. is this a situation whereby the appraiser who is being charged did an appraisal for a property owner in a
Right.
condemnation matter?
Yes.
Then the comment reflected the specific needs of the client. Would that imply advocacy on his part?
I don't see that as implying advocacy on his part.
Having been involved in numerous condemnation matters, and having not been involved in some because I could not meet the specific needs of my client, which is to give them a higher valuation, the terminology bothers me to the extent that it just sounds like this appraiser met the specific needs of his client by coming up with a high enough value to go to court. And if that's what they did, then that's wrong.
I don't interpret in the overall scope of what's been presented that to be the position. I think the position has been, and I think this was the position at trial, that there was no information that misled the client as the intended user. There was no bias or advocacy. As a matter of fact, the particular appraiser that conducted this proceeding has also, on many occasions, offered testimony many times on behalf of the state of Tennessee, and understands that in many other matters involving the state of I think his position was, in meeting the needs of the client, he in no way advocated for the client, but that the client as intended user was not misled by anything.
Isn't it safe to say, too, that the state's reviewer probably, if had there been the suspicion of bias or direction of value, I'd say that the state's reviewer would have mentioned that.
That was not mentioned. I agree.
Okay, thank you, Commissioner Hall. Are there any other questions or comments from other commissioners? Okay, is there a motion regarding the state's request? The state is requesting that we authorize a letter of instruction. But this is, if I'm not mistaken, Mr. Joseph, the letter of instruction would allow us to close this matter rather than go to a formal proceeding. And the formal proceeding would, in Mr. Joseph's opinion, be prolonged. Yes, Commissioner Stanford?
It may not be the appropriate time, but I would like to say that I feel reasonably confident that I know both parties involved here, and I don't think it would be appropriate for me to participate in the discussion or the vote of this particular matter.
Thank you. We appreciate your integrity. All right. Are there other questions from commissioners that, is there some lingering doubt here that we can address? Is there a motion not to accept the state's recommendation and to proceed to a formal hearing?
Not violating any rules, any confidentialities, or anything. Is there anything else that can be told this commission at this point in time that might help us make a decision? Need to know what was the allegations on this thing, other than, it's got to be more than the fact that he didn't use the proper definition of market value. To me, that's just a moot point. This thing did not get this far, I would not think, because of that reasoning.
Well, when
And
the,
I would like to know more about, exactly what went on before I could make a decision. And I don't personally feel like I know enough to say, close it. I have a great respect for you, Mr. Joseph, and your opinions.
well,
You've tried a lot more cases than I've ever been involved in, I'm sure, and I would not begin to try to challenge you on points of law. I defer.
Right.
However, I'm just concerned, sitting here as a commissioner, that somebody in our profession will look and say, hey, did you know blank, blank, how could you do that? Or I think you made the right decision because of blank, blank, blank. And I'm saying, I didn't know that. I mean, how can I make a decision not knowing exactly what I'm being asked to vote on?
Can I intervene here, Mr. Joseph? I think the task at hand is to make a decision based upon the points that were provided. So your choices are somewhat limited to either accepting the state's recommendation or saying we do not accept the state's recommendation because there is insufficient reason to make a judgment, and then you move to a formal hearing. And that's the format where all the evidence is produced, and that's when you get to hear the complete story. But if you don't feel comfortable in accepting the state's recommendation, then that's the normal course. But I don't think it's appropriate to put Mr. Joseph on the spot and ask for more details at this point. We have the facts, and we have what the state's requesting. So if you don't feel comfortable accepting their recommendation for a letter of instruction, then it goes to a formal hearing. That's the process. Yeah, I'm sorry, Mr. Joseph. Go ahead.
I do agree with that statement generally, Mr. Chairman, and thank you. That is a correct statement of the law and the procedure as it should be, as this matter's pending for a determination of a probable cause nature or of another disposition which is in the way of closure. However, I do think I can provide some additional objective, anonymous information that hopefully will respond without tainting any further evidence or any further contested case hearing. And that is, Mr. Hall, in matters of this nature, the complainant is not alleging, first of all, I think it's clear we do not represent, the state does not represent the interests of the complainant.
Yes, sir.
All right. The complainant, when complainants submit complaints of this nature, generally, unless they are another appraiser, which was not the case here, the complainants generally do not allege violations of USPAP, so that did not occur here. The difficulties in this case had more to do with the outcome of the condemnation trial than anything to do with the issues of USPAP, insofar as the way it came to the state. We are required by appraisal subcommittee guidelines to obtain a full review after the complaint, generally, no matter what the nature of the allegations are, in order to determine if there are alleged violations of USPAP. So the allegations are the bulleted statements are not bulleted statements submitted by the complainant. These are general concerns set forth by the state's reviewer.
Would you like to make a motion, Commissioner Hall? Mr. Joseph, what would the effect be if the commission made no vote? If we basically refused to take up the matter? Would this go to a formal hearing, or what would be the process?
The matter's still pending as a formal, so it would have to keep going.
Find out more particulars about this case on the day of the trial?
Well, I think it's important to understand that on legal reports, we're not here to try the entire case. And we're here to present as much information as we can without tainting the entire case, because you as the commission serve two roles. You make a probable cause determination, in which I am prevented from providing you all of the details so you won't reach a crystallized opinion as to judgment one way or another. Then when a formal hearing is before you, you will receive all of the evidence and you can make an appropriate decision at hearing. But in order to not taint what may come before you at a formal hearing and to taint the entire decision-making process, I cannot provide you all that information on a legal report. I'm simply legally prohibited from doing so.
Questions from the other commissioners? Okay, well, we'll give it one more shot. Is there a motion?
If I could ask a question, is it my understanding that the T-Dot condemnation trial, has that already been finalized on that end?
Yes.
Okay. I move that we agree with the council's recommendation and issue the letter of instruction in this case.
I have a motion from Commissioner Collinsworth. Is there a second?
I'll second.
From Commissioner Johnson. Is there further discussion?
Question,
Commissioner Hall?
what is a letter of instruction?
It's in which it's similar to a letter of warning. It is a non-disciplinary disposition in which we set out that the appraiser is instructed not to allow minor infractions of these provisions of USPAP to occur again, but it clearly states that this does not constitute discipline.
So we are in effect saying that this person did no wrong, that this was a frivolous lawsuit.
Frivolous lawsuit.
I mean, frivolous in the sense, if we're gonna, after all of this, we're gonna come up and say, hey, we're just gonna send you a letter of instructions, not a letter of warning, not a letter of anything except a letter of instruction.
It does the same
We
thing.
are, in sense,
It has the same effect as a letter of warning.
saying that after all of this, there's not enough evidence to bring this matter to a formal hearing.
Well, it doesn't. It does not result in a dismissal of the case. It's simply a recommendation designed to afford formal at this point without acquiescing in anything else, based upon all the circumstances.
Any other discussion? Hearing none. Let's restate the motion. The motion was by Commissioner Collinsworth to accept council's recommendation for a letter of instruction. We had a second from Commissioner Johnson. We've had discussion. Let's take a vote. All those in favor say aye.
Aye.
All those opposed?
Aye.
Would the record reflect that I didn't participate, please?
Commissioner Standifer has recused himself. The chair votes to accept the motion, so the motion carries. All right, so the state will issue the letter of instruction, please.
The next matter we have, Mr. Chairman, item number 2. We have a notice of hearing and charges in this next matter pending for a few months, and this matter was previously set for a hearing this month. Approximately 10 days ago, the respondent signed an agreed final order agreeing to pay a $5,000 civil penalty and accept a 2-year period of probation as to her certified residential certificate. The payment terms are for the respondent to pay $750 upon her signature of the order, which the respondent has already done, and $4,250 balance by February 5th of 2015. We have set forth the terms of the probation that the respondent must adhere to over a 2-year period. She has to submit an experience log to the executive director every 6 months. The first such log being due on August 5th. She has to submit 3 reports to the executive director for review within 15 days of a request for reports, and she's not permitted to supervise any registered trainees during that 2-year probationary period. We've set forth some of the multiple violations of USPAP which the respondent has admitted committing in this uniform residential appraisal report that she prepared in 2008, and the commission can see the detail relative to what she admitted. She has received, as stated on page 4 of the report, a prior consent order from this commission on April 26, 2012, where she was assessed a $500 civil penalty and required to successfully complete the 2 corrective educational courses that are set out, a 30-hour basic appraisal procedures course and a 15-hour residential report writing course within 180 days. She did not complete that within the 180-day period, and as a consequence, her license was previously suspended for several months until she did complete it later in 2013. She has indicated that she regrets not completing that corrective education required in the 2012 consent order in a timely fashion, and has indicated to litigation counsel that she encountered considerable difficulty attending these courses without having to travel between 200 and 250 miles from her home. She had to take them in classroom setting. She had difficulty getting away from her full-time job, and she also had temporary custody of her grandchildren, which kept her at home most of the time. She does not have temporary custody of those grandchildren now. She's recommitted herself to comply with the deadlines of this commission as set forth in this agreed final order, and to pay this civil penalty balance by February of 2015. She's indicated to counsel that all she was able to pay initially was the $750 presently, and that she has committed herself to complying with the deadlines regarding the conditions of her probation. Based on the respondent's agreement, based upon her payment of the initial deposit on the civil penalty and her cooperation with the state, I do not seek a revocation of her certificate at this time, and would respectfully request the commission to approve this agreed final order, which would impose the $5,000 civil penalty and place her certified residential certificate on a 2-year period of probation.
Make a motion to accept.
I'll second.
We have a motion to accept and a second. Is there additional remarks from commissioners? Questions? Hearing none. All those in favor?
Aye.
Opposed? Hearing none, the motion passes.
Third matter, Mr. Chairman and members of the commission, is item number 3. This is also a formal proceeding, notice of hearing and charges, which is currently pending. In this particular case, the respondent had come into Tennessee in 2012. He inspected the subject airport in 2012, March. He completed his report in May and transmitted the report to the attorney for his client in June of 2012. The respondent is certified as a certified general real estate appraiser in 2 other states. He did not apply for, nor did he have a temporary practice permit as a non-resident at the time he inspected the property and at the time he completed his report. He has indicated that he has performed similar appraisals in many states, not as an excuse for the conduct, but perhaps as an explanation for his lack of knowledge. and not all states, according to his statement, have required him to have a temporary practice permit to perform this type of work. The complainant in this matter was involved in a business dispute with the respondent's client. The complainant submitted a complaint in this matter alleging unlicensed practice against the respondent in August of 2012. The respondent responded by email, and the respondent admitted he did not have a temporary practice permit in Tennessee. He did promptly submit a temporary practice permit in Tennessee in either late August or early September. That was received on September 10th of 2012, and it was granted on September 12th, 2012 by Mrs. Avers' staff. The respondent had indicated to us that his client requested minor corrections and clarifications in the report, which the respondent performed in September of 2012. The respondent has acknowledged that he should have ascertained the requirements necessary to practice in Tennessee before he commenced work on this project. I do not believe that he intended to violate the Tennessee statutes. Based upon a review in this matter and based upon what has been ascertained thus far, it does not appear that we could prove other than there were 4 months in which he had engaged in this unlicensed practice, March through June of 2012. Of course, the commission has the authority to impose a civil penalty in the range of $50 to $1,000 per violation of these Tennessee statutes and all of the Tennessee statutes and rules. We do not have evidence as to how many days the respondent worked on each particular report and whether or not any of these days were continuous days. We do have evidence that he worked on this report for a 4-month period between March and June of 2012. Given the fact that the respondent has been forthright with the state, he has admitted its violation. He has indicated that he will not come into Tennessee again without complying with the Tennessee non-practice, temporary practice requirements. Based upon his forthrightness with the state believed that the amount of $500 per month of unlicensed conduct was sufficient to protect the public and would be a sufficient economic deterrent to a respondent to not engage in this course of conduct in Tennessee again. The respondent has signed an agreed final order agreeing to pay a $2,000 civil penalty if approved by the commission. The respondent has the money currently, has committed himself within the agreed final order to pay this by the end of business on February 12, 2014 through his counsel, who has the money within counsel's trust account if this is approved by the commission, but he did not want to pay it if this was not going to be approved by the commission. And I consider this a fair settlement and would recommend approval of the agreed final order negotiated in this matter.
Thank you, Mr. Joseph. I have a question for you. What was the civil penalty that the commission affixed previously?
I think that the civil penalty that the commission affixed previously might have been a $6,000 civil penalty. I don't remember whether it was more than that, but I think the thinking was that the respondent had engaged in practice for unlicensed practice in Tennessee for a more continuous period than was ascertained after the formal proceeding was filed. And it also may have been based on a civil penalty of $1,000 per month in terms of the prior recommendation.
That was my recollection as well. It was like $1,000 a month, and if I'm not mistaken, it was $7,000 or $8,000.
It might have been that. It may have come back for a represent, but I think the thinking was that he had engaged in practice from January through August continuously for maybe an 8-month period. I think I could only prove that he engaged in practice for the 4-month period. If this matter were to proceed to a hearing, the state could ask for a civil penalty of $1,000 per month if it went to hearing. But we have the ability, if in fact there are some mitigating circumstances, to not actually impose the maximum per month. And the decision in this particular case was that the respondent had been cooperative with the state and that a civil penalty of $500 per month would be sufficient in this case.
Okay, well, are there other comments or questions for Mr. Joseph from commissioners?
Move to accept.
Second.
Motion to accept the state's recommendation in a second. Is there additional comments from commissioners? I have one. If I recall, the reason why the time frame was what it was is because he inspected in early 2012. He was employed to appraise an airport in early 2012. And then on September 10, the staff received respondent's temporary practice permit. So that's why it was roughly nine months, and we were at $1,000 a month. So that's why it was set the way it was. I also find it interesting that the respondent has performed similar appraisals in many states, and that not all states require a temporary practice permit. Well, that means that he's aware that some states do require a temporary practice permit.
I think he admits that he realizes that some states do, and I think he admits, Mr. Chairman, that he was negligent in not ascertaining Tennessee's requirements before he did it.
Commissioner Hall?
Something in the back of my mind tells me that if he's doing it for a federal agency, that they don't necessarily have to have license from the state where they are making the appraisal. I was talking to an appraiser in Georgia, and he was in Florida doing some work down there for the federal government. And he was not required to have a Florida license because his client was the federal government. Now, I don't know whether or not we got a similar situation here or not. I do not know.
I do not recall enough about the details of the underlying transaction. This was airport property. There was some business dispute. Required to get that type of temporary practice permit, but I'm not really clear on exactly what those.
Wouldn't it be safe to assume that respondent would have responded that way if he didn't need a temporary practice permit? I think in his defense, we'd have known early and often that it was a federally engaged assignment. So
I don't think that defense was ever put forth by respondent. Right.
okay, we have a motion and a second. Hearing no further conversation, all those in favor say aye.
Aye.
Any opposed? Me? Motion still carries.
Thank you, Mr. Chairman. That concludes my matters.
Okay, let's take about a 5-minute break, and then we'll move to the next item on the agenda, which is the director's report. Thanks. Okay. Boy, you're Johnny on the spot here. Okay, we're back in session. This is the February 10th meeting of the Tennessee Real Estate Appraiser Commission. We've come to the item in our agenda for the director's report. So I'd call on Ms. Avers to provide us the director's report.
Are three pieces of legislation pending. Senate Bill 1620 as introduced. Is the first item, which is on your iPads as five. Bill on the pending legislation, sponsored by Representative Norris and Sutherland. And it's also, that has the companion bill, House Bill 1416 by Representative McCormick and Brooks. over.
Ms. Avers, what was the genesis of these bills? How did these come into consideration?
The background check legislation was sponsored through the governor's package.
Okay, so they were initiated by the governor?
First one. Background requirement for the federal legislation for
Dodd-Frank?
Yeah, with Dodd-Frank AQB requirements.
Okay.
Background checks, yes.
This bill, can you summarize for us? Is this going to require only new applications to be fingerprinted, or will this require fingerprints on renewals as well? Looks like it does. Item 2 is renewing.
No, this is
It
just
will
for
not apply.
initial.
Oh, I'm sorry. Will not, sorry. Okay.
Bill is just to comply with the minimum AQB requirements as proposed.
Any idea when this will come for a vote? Or has it been?
I don't.
Any questions from commissioners on this bill? Okay, hearing none. Go ahead. Did you want it? You don't need us to vote on anything, I presume.
No, just
Right.
wanted to make sure I call these each to your attention. Sunset law is the second one. All regulatory boards are subject to sunset laws, even though they pray law. Every board is subject to sunset audit. So this just extends the Appraiser Commission as proposed until June 30th, 2018. For compliance, to make sure that they're Senate Bill 0345, which is last one is Senate Bill 2081. Prior to the expiration date. Currently, there's a late fee attached to renewing if you don't renew 30 days prior to after your expiration date, if this is passed.
What is the impact of that to you as the administrator? I mean, I haven't got a chance to ask you about your feedback on that bill.
Minimal. It would only be minimal impact. Law was presumably written when that was done by mail. So status on the National Registry, everything had to be in at least 30 days. Electronic day and age, I can transmit
What about people who are late? Do they just won't be licensed or certified for a period of time, or how would that be handled if there are situations?
If they are late,
Yeah.
they would be late. I mean, that
Well, so if there's a time lag or something of that nature, I guess I'm trying to get a feel for how this will actually work.
if they're after their expiration, then
I don't see a problem. I know in the past you've talked about how the mail, you wouldn't get it for a couple of weeks or that nature. So you're saying electronically, because of email and so forth, that you don't, it's not, you shouldn't be an issue.
all of that online or by mail. As soon as we processed it, I can actually go in and difficult to, there's 2,100 appraisers. But we do a pretty fair job of keeping up with everyone. That being said, as long as people are timely. Time to renew, there could be an impact.
No.
There's no other questions, I'm just gonna go on to the next items. Discussion for 2015 key planning items. Establish criteria for the background check, disqualifying criteria. If you would turn on your criteria books to page 53. Draft the language as the board would want it to be. Background criteria. This is the minimum AQB criteria, and some of the language in there is unspecific on exactly how, you know, all candidates for initial will have to get a background check after current legislation is pending only on appraiser regulatory agencies. On items that all candidates for real estate appraiser credential do not possess a background that could call into question public trust. Applicants found to possess background which calls into question the applicant's ability to maintain public trust are not issued real property appraiser credentials. Run in the criteria before. shall not issue real property appraiser credential if had an appraiser license or certification revoked in any government jurisdiction within the 5-year preceding, has been convicted or pled guilty or nolo contendere to a felony or domestic or foreign court. I don't know how we will check foreign courts. 5-year period immediately preceding the date of application for or any time preceding the application if such felony or act of fraud, dishonesty, or breach of trust or money laundering. I would assume we're going to affidavit saying they haven't done, but obviously we have to run a background check. We probably need to establish some criteria in the rules that say if they lie on their application, it's an automatic disqualification. The applicant has failed to demonstrate character and general fitness such as to command the confidence of the community and to warrant determination that the appraiser will operate honestly, fairly, and efficiently within the purpose of the criteria. That's the one that I would say is pretty non-specific. I don't know how that, but that's up to you. And then D is all of the other things that the commission has to also consider before issuing a credential. This will have to be a criminal offense involving dishonesty, breach of trust, money laundering, civil jurisdiction actions involving financial service related actions or orders by state or federal regulatory agencies. Final orders issued by state or federal regulatory agency or foreign mentions of authorization to act as an attorney, account ask them about it or start checking them. Those are things that would these are some of the issues we're going to have to address within the rules. Have grounds to deny it. So.
Is it safe to say that maybe the good news is that there are other states, my fellow commissioners, there are a number of other states that have had background checks in place for years. Seems like Oregon comes to mind. There's a few others, but you voted last month to send Keeling and myself and another person to the Aero conference, and Keeling has the ability to network with other counsel there, and so the good news is we have a jump on these regs, and hopefully we can kind of mold theirs into ours. I would ask, I think it would be productive as we structure these criteria. I think it would be smart to be starting to keep in mind how much it's going to cost to comply with these items by the commission. So I probably don't need to tell you all that, but for instance, when we check revocation or suspension of the individual's authorization to act as an attorney accountant. Well, that's going to take someone on the staff time. And it's going to take money. You may have to consult with an outside attorney or someone in order to check the civil lawsuits and things like that. So I guess it would be smart to start to think about what the administrative costs of this are going to be. So we can, wouldn't that be reflected in the application fee, I presume?
That could definitely be grounds for changing fees, but
So, I mean,
requirement, it's going to be something we're definitely gonna have to grapple with regards to it. One of the items on the Aero agenda is defensible board decisions, and I know that Ohio and Texas are going to talk on their background checks and their board's process for denying applications
Based upon that information, this may be a meeting that all of us should go to, so we can all hear it. It might well be worth the state's investment to take everybody on the board to this meeting and make us all sit in there and listen to this.
I would agree, definitely.
That, processed, the meeting is April 11th through already in for Mr. Green, Mr. John. Asked for Mr. Collinsworth to attend, but he had a conflict.
I mean, this is serious.
It's heavy. I mean,
We
this
need
is
to
heavy
go
lifting.
and we need to be taking notes and we need to be coming up with all the things that we need to implement here. And
There
it's not
is-
something that's gonna wait on us. It's gotta be done.
There is a fall conference also, and that one will be in Washington DC.
Make a motion, we send Ms. Point then.
Well, no, I think
Collinsworth is
send,
not gonna be able to make it, can we make a motion to send Ms.
let's
Point?
send everybody that could go. Because we need to,
That's for the will of the commission. I don't. I can.
think it would be
I can
powerful.
certainly try.
Well, if we already have authorization, to send,
what about Gary?
Gary don't want to. No, let Gary speak for himself.
And
I
Rose-
personally will not be able to attend. I've got some
Well, I
personal
haven't looked at
items that
my
I can't
calendar,
do.
so I don't know, but I mean, I'm just saying this is so important. And the sooner we get a handle on it, the better. So Keating can make up our rules, that we can have our rulemaking hearing.
Because I think we're really going to have to be specific in these rules because thousand bumps in the road if we're not as specific as possible at the outset, including getting the rules passed and when people start going through this process at the beginning of next year. It really does. Process.
It's a long road to hoe. It's,
There are some background checks that are more expensive than others that go into the depth and pick up any liens you have, anything you've had a lawsuit, pick up all kinds of things, but they're very expensive.
this is not that type.
Pick up any,
requirements will be on the commission to enforce, and some states will opt by, I guess what they call attestation.
Leave it up to the honesty of the applicant
Right.
for some of these situations.
Whereas other states have go completely other end of the spectrum and run background screenings in addition to background checks. Private companies run not just your fingerprints and background checks through the FBI, but
Everything.
actually run your social security number, your name, and to see if there's any identifying characteristics. Both of them have pluses and minuses. For have a common name that might come up more frequently in not necessarily, I mean, you might ping a lot of information, and there might be a lot of Michael Greens out there. If you have a more unusual name, it might be easy to tell if you do or do not. Just as an example of background check versus background screening, your fingerprints will check that, and that's pretty much just you.
Criminal, yeah.
But a background screening is really like, I just ran Michael address, but it's almost more like a Google search. Like, I mean,
But if you were to
you'd
take
be surprised how much you can find out about a person
Yeah.
on the internet.
for $19.95. But
Right.
but at that point, if you decided to do that option, you would have to really do that on every applicant. You can't, from a discrimination standpoint. So
Right.
the cost would essentially go up exponentially,
And then for you to make on whatever you find out. Generally speaking, the applications right now, they're providing the information to us, and they still will be required to. I foresee them providing the information, and if they about their character, that would be a disqualifier. There's 2 other programs currently that are running background checks, and are much bigger boards than, big, a lot more licensees. That would be security guards. Just went into effect, so that was in January. And a lot of people that came back on the background checks. So,
I'm shocked.
Would you guys have access to the TBI computer files, or is that a?
they would report a criminal history to us. It's not, they could give us a report, essentially saying the person has a criminal history and what the not like, pulls in and she's gonna get to flip, no. If I need to see something, I have to go to the county. Essentially, we'll be comparing notes with what the applicant provided. They're gonna give us a report, not the file. It'll be data.
Basically looking for criminal information. I mean, what else do you want to know about 'em?
Well, it won't tell me many times, the report won't tell me what 5 times for DUI, but it won't tell me if you were convicted of it.
Really want to look at a gray point, Gary. Look at page 54, item 3 at the top. I mean, if that's not ambiguous, I don't know what is. I mean, that's and we as a commission are going to be asked to ascertain whether the applicant is or is not. So, I mean, that's where the water gets really muddy.
I would definitely be interested in seeing how the other states that are already doing this are planning to handle that, or are handling that right now.
It seems like there might be two issues here. Number one might be timing. When do we need to have a rulemaking hearing for this to come into effect by Feb 1, 15?
It needs to really, I mean, in all honesty, be like super soon. I mean, it
Can
just
we do
takes
that?
so
Are
long.
you capable of that? Are you capable of having these regs?
After you come back from San Francisco would be a good time to do this.
See, that's not till April, though.
Correct.
I mean, if it has to get done, then yeah, it has to get done. I can do it. It is what it is.
Could you do a rough draft that we could see in March, and then possibly after the April?
Or maybe even provide us what the other states, give us the other states in March, and at least get that in front of us so we can be reviewing that.
I don't really have another option, so yes.
Yes, I can do that. I can get you the other states.
Staff come up with this draft document and then just present it to the board, or, I mean, how's this gonna?
A lot more effective to already have your all's ideas into play before I even start doing it. Otherwise, I have to keep backtracking, and there's just no time for that. So
So,
Trying to get your thinking on it in advance.
Working session, or everything will be done in a formal board meeting?
Everything is public meeting, so we'll have to,
Not a formal
you had a
meeting-
working
it's not a
session, it'd
formal
just be
meeting
public.
For staff to get together information, is it? That's not a formal hearing, is it? A formal
no,
meeting?
it's not a-
Public?
It's not a public
all-
hearing for Keeling to be working on getting us the basic outline for this, is it?
no. We can get you the information, but we'll just have to hold them in the regular.
well, and there are notice, I guess when I talk about timing, there are notice requirements. You have to notify the public so much in advance. What are those roughly?
I don't remember exactly what it is for that, but I know that even once it gets out of my hands, once we're finished with doing everything, it's a lot of time. I mean, they hold it for a long time.
Well, we had some rules that still haven't been approved from 2 years ago. Now, that's going to really be a problem. What office?
Then? What
Why do
happens
we
then?
have
is
some that are
we-
2 years old? I don't. just-
Well, that's what I was going to ask. What office is sitting on these rules?
They're actually in the AG's office right now, and there seems to continue to be some conflict with. I've actually been talking with my supervisor about whether or not, in order to get the language to a place where it would be accepted by the AG's office, would we have to have another, I guess, a rulemaking hearing? I think we were under the impression that if you guys were going to change anything about what you did the first time, would we have to have another rulemaking hearing, or could it just be presented to you at a regular? And I'm still waiting on an answer from my supervisor on that, but it's kind of looking like I might be able to just bring it back to you at a regular meeting and do it that way. Because to be honest, there aren't really that many hang-ups left. I'm feeling pretty. So if that's the case, then hopefully we can just, Nicole's not looking very promising. I can just bring it back to you at a regular meeting rather than have to go through all of the rulemaking stuff over again, since it has been so long and now it's time to start again. So,
Well, maybe it would be helpful, productive for the commission to write a letter to the AG's office and ask them to please process this request. We certainly don't want to get in a position of conflict with the AG's office. However, this is a pretty important
right.
process here.
And I can't put something into the rules that you guys didn't say in the first place. And granted, the rules started before I came on board with this. Also been an issue, but I mean, I can't just change the wording if I want. So it's kind of just been, I'm sorry, I know it's confusing. It's hard to understand what could possibly be taking so long. It's hard for me to understand, but remedied, and hopefully I will get to present the stuff to you just at the next regular meeting and just get those issues resolved so that we can just get this processed.
Maybe a letter that we write could invite them to come and visit with us as well, and also invite their early and active participation in this new rules that we have to come up with. If they're part of the process, they won't be part of the.
Are they aware of the time frame we're working under?
No, I'm not. I've tried to make them aware. It's just a totally separate entity, so it's difficult to really know what they know. They operate completely separately than we do. So
I think at least on this, as Nicole mentioned, if we can discuss and let them be aware of the fact that this is an emergency situation, otherwise we're out of compliance with a federal ruling,
I mean,
maybe
it
that
certainly
portion
can't hurt.
there.
A rulemaking hearing held 2 years ago. A lot of things that were covered, and it was, the will of the commission, and it was a background check stuff, which we really can't hold rulemaking on until passes. You can't really have a rule that pertains to a law that is not.
Happens if we go into non-compliance?
Want to know.
Yeah.
I'm just curious, I don't.
The subcommittee has several powers now. It used to just have the power to deregulate a state, which is a pretty big axe to wield, but it was essentially the state's version of a death penalty, like no loans in the state that would be federally related, which is a pretty big, like no, you're off. So anytime a federal loan would be made, out of state appraisers would have had to have been used. So, somebody would come in from Kentucky or North Carolina or another state to do a federal loan if Tennessee, per se, were deregulated, which is kind of crazy. So the subcommittee had a big axe, but they just about never wielded it. They warned a couple states pretty heavily, and they came really close to deregulating a couple states. I won't name any names, but they never actually deregulated anyone. They came close, but they never did it. They have other powers now that Dodd-Frank gave them, which includes the ability to fine states, which they've never had before, but I won't be surprised.
Wrote a letter to the Attorney General up there outlining these potential problems and say, look, we need for you guys to act up there now because we're facing, and we don't have a lot of options here. And this is what's gonna affect the entire economy of our state. So you've got to take action. You can't keep procrastinating.
Maybe we would submit that along with the recommendations on this.
You
I don't
think,
think they really understand the problem up there, what we're faced with.
would it be more effective if that letter came from the commission or not?
Probably, just because, I'm in communication with them on.
It hasn't happened so far. Well, I'd like to see that letter. I don't know if it requires a vote or a motion or not, but,
I really hate to be a problem, but my pen just died. Do you mind? Sorry.
We have worse problems.
I write this down. I apologize. Thank you. Sorry.
that was a timely ineffectiveness there. That's kind of metaphorical.
Yeah, I apologize, but I think you probably want me to write this down.
Well, how about,
Thank you.
how about you compose a letter, and we ask for them to please process the rules that we've already submitted. We invite them to come and talk to us about how we improve this process and make it more efficient. And thirdly, we invite them to participate in the rather substantial rules that we're drafting right now and have to come into effect January 1. If you'll compose that letter and have it in our documents for next meeting, then the commission can decide, hopefully, that they want the chair or someone else to sign it, the director, or whatever. I wouldn't have a problem signing it. But the definition of stupidity might be at hand here. We can't keep doing the same thing we've been doing. So, the other matter,
To him beforehand. I mean, if you could get it to Chairman Green beforehand, that would be good.
thank you, yes. Thank you. The other issue I see, if Commissioner Hall has a conflict with the April Aero meeting, that would still leave 3 other folks that might benefit from going. So,
We all have to check our schedules.
so I tell you what, if you don't vote on it today, I can guarantee it won't happen. So what you might want to do is ask permission, and then if you have a conflict and can't go, then so be it. But it would be important to make a motion to some effect regarding 3 people in Arrow.
We wanna get
Yes, but I think Commissioner Point's point is that it would benefit everyone to go based upon these substantial changes.
all. Correct. My 99-year-old mother's not in good health in Virginia, and I'd be kind of But would you be able to attend?
I will need to look at my calendar at work, so
So is there a motion? This would be a good time for a motion, or not.
Well,
You could put in an additional request, couldn't you?
So moved.
Right? So a
Second.
total of 9, a second. Is there any other discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None. Motion passes.
Ms. Avers might want to take a survey to see exactly who could possibly go before she submits the request.
I think that's wise, yeah. Well,
Letter that the Keeling was gonna write, well, I'll make a motion that
I'll second the motion.
all right, well, discussion would be, we were going to let you see that letter before you authorized me to sign it. I appreciate that power, y'all, but let's,
no, we want you to sign it, Mr. Green, that way you get all the credit.
yeah, thank
and on
you.
the flip
Thank
coin,
you.
all the,
It's not my decision. It'd be the will of the commission, thank you. So, there is a motion, there is a second. Is there further discussion on this motion, which is for me to sign this letter?
I think maybe we may want to revise the motion immediately that you sign it, but at least that we can review it as a group.
Say, close your eyes and sign it.
That's right. Be careful what you authorize. All right, is there any additional discussion? We can vote on the motion. All those in favor, say aye.
aye.
All those opposed?
Now, wait a minute, is this, if this is to let you sign it immediately, then I would oppose that.
Thank you, me too. Has everyone else voted? All right, well, the motion carries, so, I didn't have political aspirations anyway.
You're good
so-
over there for him, Keeling.
I'm starting to think you guys don't trust me to write this letter.
No, we absolutely trust you.
Some other items that are less controversial, and we will need to define good standing, although I don't think a lot of states have addressed this. I do think it's actually going to be an issue. Part of the requirements, if you turn to page 55 and look down towards, item B, the supervisor trainee requirements, we have to identify that the supervisor be in good standing for 3 years.
I'm sorry, you said
letter B.
55, I apologize, I'm on
Yeah,
56.
page 55, letter B, right in the middle.
Oh, wow.
And it kind of defines, we've never defined good standing. It does sort of say good standing, but it says, in the last sentence, a supervisory appraiser subject to a disciplinary action would be considered in good standing 3 years after the successful completion of termination of the sanction imposed by the. If the commission were to discipline somebody, say, for 3 days, they couldn't have a trainee again for 3 years after that 3 days. So we're going. And the criteria we're gonna be that not really controversial. It's also on page 74.
I reckon the term good standing means there's no outstanding matters pending against him.
Yeah, that's kind of why we need to define it, but I can certainly give you my input whenever we're talking about the draft and all that
And
good
I
stuff.
think they're giving their consideration of what it is. It's just we have to determine whether or not we agree with that. I mean, they're saying a supervisory appraiser subject to disciplinary action would be considered in good standing 3 years afterwards. So it's whether or not would we want to just agree that that definition is for a period of 3 years prior, no to some extent.
But if we're going to enforce a restriction.
Oh, I know, we've gotta have it,
In the rules, we're gonna create a restriction in the rules. We're gonna restrict your license in such a way. Anytime you create a restriction, you wanna have it in the law and rules. The authority to restrict somebody's practice, but if you're gonna create a restriction,
otherwise you're gonna be arguing what the definition of is.
essentially,
To some-
yes.
you know.
That's what I'm getting to, is that you're going to have somebody say, well, I'm in good standing. No, you're not. I mean,
Is the word is or is it in? What is the definition of in?
Is you is or is you ain't.
and this is another place where it applies on page 74. Existing credential holders in good standing in any jurisdiction shall be considered in compliance with AQB standards or criteria if they've passed an AQB approved qualifying examination for that credential. This applies to reciprocity, temporary practice, renewals, applications for the same credential in another jurisdiction. All credential holders must comply with ongoing continuing education for state renewal procedures. The intent of the AQB is to allow credential holders, current credential holders, who are in Guide Note 5 is a particularly touchy situation that, or touchy guide note that, because it pertains to reciprocity. So Guide Note 5, although not mandatory that states implement this reciprocity. And it's how the AQB interprets the criteria.
Have any idea where you might come up with the definition of good standing then, that we might look at next meeting?
I would just use that, the guide, or page 55.
Okay.
having had, basically it'd be something along the lines of saying that the appraiser would have received no disciplinary action within the 3 years prior to.
So that would apply to in-state and out-of-state. So if you want to be a supervisor of a trainee, you can't have had any discipline, this state or any state, in the last
None.
3 years.
Zero. Zip.
But when you say discipline, does that include a letter of caution, a letter of warning, or a letter of instruction?
That would, Tennessee does not consider those to be discipline. However, some states do consider it discipline, so I would have to call that state and verify whether or not letters are discipline. On the registry, anything that is put on the registry, other than suspensions, revocations, and voluntary surrender, and the states have to verify. So
Is everything put on regardless?
caution to be discipline. We consider them guidance. And they can be considered future discipline if it's imposed.
My question is, so those aren't put on the register? Okay.
Don't you think, because we are somewhat confused by those three terms, don't you think it's important that that gets mentioned in this definition of good standing? I think that would be very helpful, because there's a lot of appraisers that we send letters to, and I think it would be really hard for them to understand that they could not supervise someone or could supervise someone. I think it needs to be very clear that a letter is not disciplinary action.
That would be fine.
Yeah.
Exactly the kind of feedback we need on these rules, like what needs to be in there for the board to understand or to tipping point on when somebody is or isn't, because staff is gonna have to look to the rules to tell somebody yes or happen very often, so please don't think this is a regular occurrence, but we've had somebody apply before, and the supervisor
Well, I think
told the trainee, but
the commission's gonna receive a boatload of feedback regarding this supervisory appraiser requirement. I can assure you, because this is gonna affect appraisers' livelihoods significantly. So, I think my point is we need to go very cautiously and carefully, and also, is there any appeal process when they are denied the supervisory credential? What is their appeal process? Is there any? I assume that staff will deny it.
yeah, any application, if it were denied, would go to before the board if
That's something that will need to go in there.
That's my point. I think that needs to be in the regs.
Rest.
Yeah, so that appraisers know, look, if you are denied, you may appear before the commission.
Well, look how few registered
Think-
trainees we have.
I think, well, I don't know if I
It's
would
about
consider
half
that
of what it was when I came
few.
on.
That's a good portion of our. Let me click on the library. January 1st, 2015. Everything goes into effect January 1st, 2015.
That means everybody, if you're gonna be a supervisory appraiser, you gotta get it before that point in time.
One thing that I didn't know before, and I did want to point out, I thought that it was anyone who did not have, or anyone who was wanting to have a trainee after that date. The Q&A that I sent to you, I don't see it in here. Did that get merged, Dennis? The Q&A from the AQB?
Yes,
Did that
it's
get-
on there.
In here.
It is.
It's off today.
Supervisors and trainees that are currently in place, and again, this is up to board interpretation.
What page
The-
are you on? Thank you.
Current supervisors and trainees could be interpreted by the commission, kind of to move forward. It would only be initial applications for supervisors and trainees that have to take the supervisor trainee course and requirements. So, if you already have a trainee or you already are a supervisor, I did not know that the AQB was.
Unless you take on another new trainee after January 1st,
Right.
even though you're an existing supervisor. At that point, you would have to take.
So there is, I guess you'd say there is a grandfathering provision if you have
Just for
trainees.
that.
To an extent.
Yeah.
Unless you
Right. That has held pretty consistent.
Has it
for-
been consistent?
It's held pretty consistent since 2007.
And that's when it dropped.
It went up in 2007 because of the 2008
8
rate.
requirements, and then it went down.
And it went, the number of licenses is the one that is actually dropped. Because of the FHA. That category has lost a lot of, really over half of the amount of, they used to have over 200 in that category. but that's mostly through upgrading. A lot of people have upgraded from licensed to certified residential. Some have retired, but a lot of them have upgraded to either certified residential or certified general, mostly certified.
I think it would be a service, the next newsletter that we publish, I think it would be a service to let people know. We've already informed them, I think, a lot about the new requirements, but I don't think we've dwelt much on the supervisory change. And I think an article based on, just on that would be very helpful to the appraisal community. Because it's, like I said, that's a lot of people's livelihoods there, both beginning and even mature appraisers. So
Well, I think I will know a lot more about that after the Aero conference. I'm still learning on that myself, and I assume the commission members will also.
I think Commissioner Point said she would write that article on the airplane on the way home.
Commissioner Point doesn't write articles.
Mr. Johnstone's a heck of a writer, and he's very silent on the issue today. You know how it is when you're not in the room.
Making a fantastic point.
I think, yeah, that's a
If
good
you're
point.
not sitting at the table,
So he's volunteered to write the article then?
I think so. Yeah. Okay. We're in agreement then.
No one said I was
Motion.
nice.
Yeah. Do we need a motion to skewer Mr. Johnston?
I don't really think you need a motion to do that, but
Okay. Tell us some more. So,
tell us some more, all right.
is it possible? Do you need any action from us in March on the supervisory trainee issue? Do you
You
have
should
any proposed
probably-
rules?
I would like the commission to define, at least in their minds, how many hours the supervisor trainee course should be, how many hours, specific to each of the components. The supervisor course can be a but it has to contain the Tennessee-specific portion. That's one of the Q&A questions on the release. That was part of the criteria. But the Q&A is actually very helpful for understanding the criteria. If you turn to on your iPad, I think. Starts down, yeah, on page 12 at the bottom. I'm an education provider, and notice the majority of the course content, section 3 of the supervisor trainee course outline qualification criteria currently contained in the first section. Well, actually, we're asking about the CAP approval. I'd like to submit the base course, minimum requirements, and not the state requirements. Unfortunately, they can't do that because you can't get a course CAP approved and have it be additional. Portions.
So does the AQB have course content then for the supervisory course? And could we see it?
The AQB doesn't write content, it has just an outline, and that's in your criteria.
Anybody have a course yet, Nicole, for supervisor appraisers?
Actually, several schools have a supervisor training course. Appraisal Institute, Trees has one, McKissick has one, and I think Columbia is developing one, but those are specific to the generic part. We're gonna have to approve them specific to the Tennessee part. And each state is handling it differently. For example, North Carolina is going to have a train the trainer, that where the commission, the board, is going to train the instructors on their rules, and then allow advisor course. Ohio and Kentucky are just doing the courses themselves. I don't recommend you go with that option.
All right, that's a supervisor. How about the trainee course? Is that course for the trainees also to tell them what they've got to do?
It's the same course.
It's the same course? Okay, it's one of the same.
Yeah.
Okay, it's not two separate courses. Okay, gotcha. All right.
Same course. It's trainee / supervisor, not.
I don't see that content outline. If I could,
It might have been added afterwards.
I would weigh in
I
a
might
little
have
bit
misspoke.
here with my Aero experience from the fall.
Is that E-R-O-W?
EROS. No. No, it's one thing to supervise your trainees technically, but I think there's also something that needs to be included about the Hall effect, which is lending your experience and your knowledge and sharing, it's one thing to say, read the book and come back and, when you've got your report done, just let me know. But it's quite another to be hands-on and to lead. So I would challenge the commission to think about that and to include that in this criteria. It's not just technical proficiency, it's all about experience. So while you're thinking about how this criteria fleshes out, how do we incorporate that? Or do we want to? Maybe the commission does not favor that, but.
Item number 6 are some criteria that would affect the supervisor's ability to supervise.
Item number 6 in, where are you?
In the Q&As.
Okay.
They've actually outlined some examples of when it would essentially be not good standing. Item 7 is some examples what would not count. They've indicated if it's just a civil penalty or education. That wouldn't be a condition where somebody would not be considered in good standing.
Basically, someone could come before us and we could have a fine plus an education requirements, and that would not count.
That would not put them out of good standing. But if they had a suspension, revocation, obviously, or if they were subject to any probation where they had a restriction on their license, that would be. As an example, one of the orders you all approved this morning not allow them to supervise trainees for 2 years. That that was a restriction. Under the if this were 2015, that restriction would be 2 years past, or be 3 years past the end of that term. So,
It'd be a 5-year period, basically.
and you'll just have to factor that into your decisions after 2015. I mean, certainly the commission's authority to decide what the appropriate discipline is for somebody, but I'm just saying, factor it in.
I think it would be super helpful if we could get some language on this supervisory trainee rule as soon as possible as well. I don't know where we'll get that, but if we could get some drafts, just as we're getting drafts to look at on the other matter, on the background checks.
Do we have an educator yet, Nicole, appointed?
That
That's
would be
gonna
me.
happen soon? I mean, what's,
Sorry?
are we gonna have an education member anytime in the near future, or do you? Applicants?
You need action on our part in that regard? Okay.
One of the things that you all, I'm getting so southern, excuse me. Item C, there is a loophole in the continuing education for out-of-state licensees. Reciprocity. We have 35 states that we have reciprocity agreements with, although now we have to, under Dodd-Frank, we have to acknowledge all out-of-state credentials. So we really have reciprocity with everybody. We have 35 states that we have formal agreements with. If we have a formal agreement with them, we acknowledge their continuing education. So that's their perk. If we don't have a formal agreement, they have to comply with Tennessee's education requirements, which may be more restrictive than some of the other states' requirements. So you could live in the adjoining state, have less restrictive continuing education requirements, and we acknowledge it.
The bottom line is Dodd-Frank says that we have to provide reciprocal.
We have to give them the credential. The AQB criteria say that we have to give them the credential, but they have to keep up with the continuing education for the requirements of that state. So you can either have an open door policy or more restrictive policy on continuing education. We've always had a very moderate open door policy on the reciprocal states that we have agreements with, where we just acknowledge their education. But we have 20 other states that we just make them do. We don't have an agreement with Illinois, but we do have an agreement with have an agreement with Florida.
So what are you, I failed, I didn't get a question or a statement there. What are you asking of us?
We just might want to define whether or not we will accept the continuing education from the resident state's jurisdiction, or if we're just going to continue. Right now, they're really, we don't really address under our reciprocity section of the law. We don't really address continuing education at all.
State then the other state will provide you reciprocal licensing. Standing means that you have met your continuing education for the state.
That's only on the initial credential. So if you wanted to go to Kentucky, your first time ever, I don't know if you've ever gone to Kentucky and had a credential. So they have to grant you one credential, first time. If you want to renew it, you have to do what Kentucky says. You have to do whatever Kentucky says to renew. So you have to meet their continuing education requirements to renew. Or they could just go, okay, whatever Tennessee said is fine. But the subcommittee doesn't dictate that you have to keep renewing a reciprocal license. You have to grant the credential. Dodd-Frank doesn't say you have to grant the initial credential based on good standing, but after that, they have to comply with your home state's requirements, whatever the home state requirement be. I recommend having a very moderate policy, an open door policy, but currently we don't have any policy on it. Like,
So your
just don't have
recommendation,
it- right now, it's up to
Yeah.
essentially my interpretation of
Okay,
the
when
rules.
when we give reciprocal, is it for a specific job, or is it just to practice in the state?
No, it's a two-year credential.
Oh, okay, the reason I asked that question, no, the times that I've applied for, like in Alabama, it's been a quote for a specific job, a specific time frame. And then
Temporary
it's
practice
and it's only good, for that period of time.
Yeah, it's
They give a reciprocal license, fine, but it's not for a blanket, it's for that specific assignment.
Two different types of credentials. Temporary practice versus a reciprocal license.
what is your recommendation then, the states that we don't have an agreement with, we would just be lenient, or we would impose the Tennessee continuing education?
I would recommend my personal opinion is that we eliminate the reciprocity requirements and just have an open door policy if they're in good standing. That's the easiest route to go. And renew them on. But requirements to be fair for everybody. So if you're going to hold people to a certain level of education,
Saying do all the same way, every state. What are some of the other states doing, do you know at this point, with regard to this issue?
it varies by area. A lot of states just renew you if you have a credential in another state.
That's what Florida does, is it not? Florida makes you adhere to their requirements, as well as I recall. Is that correct, Mike? Is that what you've heard?
Yes. They make their own standards.
Yes.
Why don't you, in the interest of time, why don't you formulate what you recommend? Why don't you give us bullet points as to why you're recommending it? And why don't you submit it to us in March for us to consider?
Okay.
Could we get that beforehand, if possible? Email possibly?
Just have to tell me what you want.
Look at it.
Oh,
Item D, discuss continuing education plan for distance education. We discussed this previously, whether or not Tennessee wants to consider allowing qualifying education and continuing education. I printed out for your information the IDEC approval minimum criteria. That's not the application process, which is a lot longer, but I did print out the IDEC approval. I also printed out some additional information for you.
What's this?
There is only one school that offers the certified general courses in classroom currently. And there's only 2 schools that offer the residential courses in classroom currently. So I printed out the courses of those 2 schools, and I'll just pass that information around. I also printed out the entire approved course listing, but I didn't make 12 copies of it, just so that you could get a perspective. Held in classroom around the country. A school that offers it in classroom. So you can imagine how difficult it must be for a trainee to take courses in classroom.
Going to provide a recommendation on this issue as well?
I have recommended in the past, and I still recommend that Tennessee
The distinction is for qualifying education, right? Not continuing education.
We already approve it for continuing education up to 14 hours per renewal cycle. I would recommend we approve it up to 28, the other states that are join us allow it, and we're allowing them to renew based on capacity. So we're holding our licensees to a higher credential.
I assume the majority of all states allow 28 hours of continuing education.
I think it's over half, yeah.
Online, you mean?
Yeah.
Yes, sir.
Why don't you make that recommendation as well, whatever that is?
Recommendation, officially and in writing. And one thing I just discovered while going over the criteria, because it's great reading, is that for many years we have had a disqualifying criteria for continuing education, that the exam course not be approved for any continuing education. The exam prep courses not be approved for continuing education, that you don't get any CE credit for that. It's actually written into our rules. It is 55-2.06.
That's the rule number?
But I was reading the criteria, and the exam prep is actually not that's actually not in the criteria. It's just a Tennessee thing. So I was recommending, it's on page 70, 78 and 88 of the criteria. Right, that the exam prep course could get counted for. Question 3 on page 88. I'm a state regulator charged with reviewing and approving courses for CE, and education providers submitted CE courses that review are designed to prepare candidates for the National Uniform Licensing and Certification Examinations. Can state approve an exam prep course for CE? And response from the qualification board is nothing would prohibit a state from approving a course that prepares individuals for passing the CE. long as it's 2 hours in length. So, there's at least one school that offers an exam prep course, and I'm sure there's several others that would offer it as an course.
Let's take an informal poll amongst the commissioners. How many people think that an exam prep course is not useful for CE? I think it should be allowed. Is there anyone that doesn't think it should be allowed? Okay. Well, I think maybe it'd be good then to change that and submit that in your draft rulemaking materials. Like we're in agreement.
Okay. The rest of the information is just board information on the director's report.
Looks like we've got money to send everybody to the Aero conference to me. First class would be nice. Thank you for the director's report, San Francisco. Yes, Commissioner Hall's asked for a break of 5 minutes. We'll adjourn for a short duration, and then we'll come back and we'll finish. We won't break for lunch today.
We're not gonna break for lunch.
No. Okay, we're reconvening the February 10th, 2014 meeting of the Tennessee Real Estate Appraiser Commission meeting. We've just concluded the director's report. Has everyone had a chance to review the January commission meeting minutes? And if so, is there a motion to accept them?
So moved.
Motion to accept. Do I hear a second?
Second.
Second from Commissioner Standifer. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? None opposed. Okay. Next item is the experience interviews. We had 2 experience interviews this month. Place my experience interview.
I was the first one, if you
Okay,
want me to
Commissioner
answer.
Collinsworth, please.
I had an experience interview this morning with Nikki Correll Ward. She's trainee, and she is attempting to upgrade her license status from a trainee to certified residential. And after the interview and discussion we had, it is my recommendation that the committee vote to approve her upgrade request upon passing the exam from a trainee to certified residential.
Okay.
I know one time we discussed that, and we sort of amended our verbiage there because we can't necessarily approve her going to certified residential. She actually has to pass the exam, so
Thank you. That's a
worded that properly.
interesting clarification. Thank you. All right, so we have a recommendation. Do we have a motion?
I so moved.
So moved by Commissioner Point. Is there a second?
Second.
Second from Commissioner Johnson. Is there discussion? Hearing none. All in favor say aye.
Aye.
Any opposed? None opposed. Motion passes. Ma'am, are you Miss Ward?
No,
Okay.
she is not present.
Okay, all right. All right. So, who did the second
I
experience
did.
interview? Okay. Commissioner Hall?
I interviewed Linda Matlock White. This lady had been here last meeting and had met with Mr. Standifer, and she'd been requested to prepare a commercial demonstration report that shows all 3 approaches to value and 2 additional reports, which may be agricultural/farm appraisals. Ms. White does mostly farm appraisals, agricultural appraisals. However, in order to do these at the level of it, she needs to be a general certified appraiser. She submitted a report, and unfortunately, it was more of a summary report than a demo report. She has the material, she has the information. I've asked her to please put that in a form and resubmit it to me. I'll ask Nicole, when she does that, send it directly to me, let me review it, and I can pass judgment on it. And with the approval of the commission, we'll let her sit for the exam. Approval?
I guess I didn't. Part of it, could you just clarify the first part when you were saying the demonstration report? Could you just, I didn't catch that.
The report that she submitted was more of a summary report than a demo report. It summarized the data, but did not actually explain and go into detail as to how she arrived at the numbers. And so I asked her to please provide me with that information. And once I have it, then I can go ahead and approve it, because I know she can do it. And so, Council, what I want to do is, and so that way it can expedite the matter. So, once that takes place, then she can set for the exam and move forward. And if
So the recommendation I hear is the report that was submitted was not sufficient in explanation to make a clear recommendation for the approval. You want to see additional information, not a report. Is that correct?
correct.
Okay. All right. Commission has heard the recommendation. Do I hear a motion?
So moved.
Motion from Commissioner Stanifer. Is there a second?
Second.
Second from Commissioner Point. Is there any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? None opposed. Okay, now it's my understanding, Ms. White, you wanted to address the commission? You want to address the commission. Okay. Step to the microphone and introduce yourself and your position and where you're from and
My name is David Brown. I'm Ms. White's sponsor in helping her toward receiving her certification. I was here last month also with Ms. White. We met with Commissioner Staniford, and it was our understanding during that particular meeting, the work product that Ms. White has provided to the commission today met what we felt like he was asking for at our last meeting here. I would hope that if we misunderstood that you would clarify with us, because it was my understanding that you wanted to see Ms. White's ability to complete that type report with all three approaches. And actually, we asked for some guidance from you, and you just suggested to pick any particular piece of property, and we could do a drive-by on that and could present that information back here. We feel like we have complied with what you have asked us to do, and I would respectfully ask Mr. Hall and the rest of the commission to reconsider the decision that has just been granted here. And that's all I have.
Yes, sir. Well, we appreciate you being here, and we appreciate your interest in your trainee. You are accurate. I did ask for a demonstration report, or I guess Nicole actually made that recommendation. She was in the initial interview with me. I have not looked at that report, so I have to defer to Mr. Hall. I did request it, so I really can't. I can't say because I haven't reviewed the report that was submitted. The data there, the reports that were submitted initially, again, I felt like you guys were doing a lot of good things. It wasn't at a level that I was comfortable with regard to a certified general, with regard to the type of income approach and three approaches that you typically see on smaller commercial properties or any commercial property. And that's why that I had asked for the additional report.
Sir, and we were glad to provide that for you. I'm not here trying to get out of doing something. This is our second time here. Miss White and I took advantage of the 500-hour interview. We came and met with Commissioner Carter at that time and submitted reports for his review. We've tried to do this the right way, and, you know, I'm having a hard time understanding where we're dropping the ball here, so to speak. You know, Miss White has gone out of her way, I think, to comply, and so have I. And I feel like and would hope that Ms. Avers would, if there's something that I'm leaving out here, would correct me on. But it was my understanding that the report that we could supply could be in a demo format. There was not anything mentioned about whether it was a summary format or, you know, we have the information and we can certainly go back and supply you with whatever you're asking for. I just would like to ask for your reconsideration that we feel like we've done what was asked for at the last meeting.
Brown, appreciate you coming forward, and I enjoyed my conversation this morning. However, I think she will tell you that I went over that report with her very thoroughly and explained to her why I could not do that. I do not think it's adequate when you tell me I got a 3.8 acre tract of land and the value is between $12,000 and $18,000 an acre, and so I'm gonna pick 18. There's no reasoning, no discussion, nothing there to lead me to follow her train of thought. She's got the information, she's got the knowledge. I want her to tell me that knowledge. The cost approach, I'm gonna use a figure of X amount of dollars. Where'd you get it? Oh, I talked to some builders, I got it from Marshall Valuation. Fine, show me your explanation. Show me how you came up with it. Right now, all I got's a number. We are not trying to be unfair to this lady. She's got the information. I'm asking her to please give it to me, present it to me, so I can follow her train of thinking, okay? That's all, nothing else, nothing more. No more than we require for anybody else coming before this commission. And so I feel like we're trying our best. And I went so far as not to say, I deny. No, I said, prepare this information, you got it, send it to me, send it to Nicole at least. Nicole will get it to me, I'll review it, get it back to Nicole so that we can get this thing moving forward, so it'll be as small a delay as possible. So we're bending over backwards to try to accommodate you and to try to accommodate her. I don't know what else we can do. And I'm sorry if you don't appreciate what we're trying to do for y'all, but we are trying to help you.
I just thank you for the opportunity to let me address you.
Let's make sure that we're constructively moving ahead. Ms. White, do you feel like you know precisely what Mr. Hall would like to see? Did you take notes during your interview? Okay. Well,
Well, like I told you in the review, like on the land sales, you listed about 5 land sales, and you listed the total price for those land sales. Nothing in there about per unit, since this was an apartment complex, how much it sold for per unit, per square foot, per acre, per nothing. I have nothing to follow you on. What I want you to do is provide me with some analysis on this property. I'm not expecting the detail that I would get on a demonstration appraisal report from the Institute. If I did, that'd be a 100-page report. I'm not expecting that. But I do expect you to give me some reasoning and analysis of why you did what you did and not just give me a number. Okay?
Paul, if I could intervene here. And now, so you now have a third opinion. And here's what I would say to you. Your report needs to be communicated in such a way that Mr. Hall could you need to provide enough detail that Mr. Hall could come to his own conclusion. So it is not the level of a demonstration report for an MAI. But, and maybe that's, I think we're hung up in some syntax or terminology here. We need your reasoning. The reader, pretend we're not Tennesseans. Pretend that we're in California. We need to understand why you chose your comps, what you did with your comps, and how your comps led to your conclusions. And I sense that this is an agricultural appraisal. It was not. It was.
No, it's department.
It was an apartment. Okay. Well, even more so then. So we need the. It is not just a summary of your conclusions. It's how you arrived at them, and that's. If you need some guidelines, if you really truly feel like you still don't understand what the content should be, I mean, ultimately this is USPAP stuff. So look at the income approach in USPAP, specifically Standard 1 and Standard 2. Standard 1 is going to talk about how you should do it. Standard 2 tells you how you should communicate it. So look at those, and particularly the income approach. Okay, well, perfect.
Right, and the sales comparison approach, where we got some units of comparison in there also. Yeah, and the write-up on each sale about the age of them, the square footages, number of units, rents, etc.
We want you to succeed, but remember our goal here. We're giving you a credential that will allow you to appraise unlimited value of property. So we sort of feel a responsibility to protect the public, and this is our only chance to help you get to that level.
Can I add one thing, Chairman Green?
Yes, sir. Commissioner Stanifer.
And I think Nicole made the recommendation as a demonstration report. I don't think she meant a demonstration report like for, a professional appraisal organization. I think she just wanted you to demonstrate that you had used the 3 approaches on a commercial property of any type. So.
That's what I'm hearing, yes. And
We will expedite it as soon as possible.
and we certainly don't want we don't want to cause hardship. So if you want to send it to Ms. Avers and let us look at it and process it in the interim, we don't want to delay you, and we don't want to make you make another trip. Tennessee's a long state. So do you feel like we've addressed your concerns, y'all? Just communicate those. Yep. Okay. All right. Moving along then. Thank you. And I'm sorry that we made you endure the rest of our meeting. I apologize. Safe travels. Okay. Next item on the agenda is the education report.
Well, given that Dr. Brella was not able to attend this month and that we're going to need to start reviewing information, Dennis and I reviewed the education this month. Review the information carefully that's included, and for any reason you have a problem with any of the information, let us know. But we have 4 items for continuing education presented that we recommended for. 2, well, it's one person's request for 2 courses for individual courses. Robert Abbott requested individual course approval we recommended for approval of one of the requests and recommended not approval for the second. Of significant concerns, I'm just going to cover the topics for the reasons, the reasoning for the recommend.
Before you do that, this is for continuing education. Is it possible that there's a typo? Did you maybe recommend for the bottom one and against the top one? Okay, so you're recommending that we approve a course called Louisiana Real Estate Contracts, and you're denying that the request for, I guess that's Tennessee Real Estate Commission legal update.
It's not Tennessee, it's Texas. They just happen to have the same acronym we do.
Okay, so Louisiana and Texas.
Yes.
And this is so that they can get CE in Tennessee.
Yes.
Okay, all right.
Abbott has requested CE, and he has all but 6 hours of his CE met. So he only needs 6 hours. He's asked for 10 hours here. 4 of the hours appears to meet our continuing education rules requirements, and we did include a copy of the 1255-2 if you want to click in your iPads. Oh, and they've got a hard copy too
It's a hard copy, yeah.
of his, the one we recommended denying on.
Page is it in the iPad, please?
Yeah, what page is that?
It's just the hard
Handout.
copies, guys.
Well, it's on the iPads too. If you click on your library,
That's fine.
touch the screen and then click library, and then just click rules.
Okay.
Well, 55-6, which would be 1255-2.06.
It's not gonna be.
Oh, no, not on the printed copy, on your iPad.
That's the electronic one. Page 31, you said?
5-2
Yep.
that started.
I don't think it's on the hard copy.
It's not,
Not the entire.
this one's the
part.
electronic.
Page 37 starts the continuing education requirements on the rules on your iPad. The whole set of rules is on your iPad. And if you touch the rules on your iPad, page 37 is where the whole continuing education section is. We thought you'd have the most concern on the one that we recommended denial for, so we just highlighted the reasoning for denial.
Texas a reciprocal state with Tennessee?
It is. That's not why we did not recommend a denial for it. It was part of the unacceptable topics in our rules.
Real estate law, basically.
And he's not
Tra-
he's not a Texas appraiser. He's a Tennessee appraiser.
I understand the denial. What Louisiana real estate contracts, what principally fulfilled the requirements for that course? And I ask this because typically I get denied for those requests. I mean, if it's got another state's name in it, I can forget it. I understand. So it basically did this course, this dealt with all real estate contracts, and it was informative because it taught them about them.
It was also taken from a school of appraising. So this is one of those rare courses where brokers can take it and appraisers can also take it because it sort of covers ground for both professions.
We could cross out the word Louisiana and, okay. Louisiana's a lovely state.
Lovely, lovely state with many fine attributes.
It's irrelevant. So, all right. So we have your suggestions here. Four courses, FOUR courses, you've recommended 4. And 2 courses and then for Mr. Abbott, you have 1 up and 1 down here. Are there any other questions or comments from commissioners? Hearing,
But that is solely based on the topic of the course as opposed to the content?
Well, and one of the problems with just approving on content is, unlike the course providers, he did not submit a timed outline, so we couldn't just approve partial credit because there is no timed outline for any of the material he submitted. So it doesn't say like 2 hours on this topic. It's sort of an all or nothing kind of content. He only had the information as fractionally submitted, so.
You know if he just doesn't have it, or I mean.
This is what he submitted. He also submitted a second USPAP course taken a few months ago. But
duplicative.
which might be something else the commission should address in the more specifically. And let's say about repeating courses, but
Say that they can only take the USPAP update once every 2 years? Is that what you're thinking we need to?
Credit for it.
It already says you can take it as many times as you want, you're just not gonna get credit.
Well, I don't know if it does say that based on what she's saying.
Well, see, there's a 2012, 2013 you could have taken, or the new one that just came out, you could have.
taken, and he did take both, but,
Maybe we need to specifically indicate that
The
you're
7
only
hours.
given
7
credit
hours.
hours once every 2 years for the required 7-hour update.
I think it says that already. I thought
It does.
He took the 2013, 2015 one in 2012, is that correct?
yeah, he took them within 3 months of each. December, I think it was, and then again in January.
Okay, so
So he could have gotten credit for either of them.
Either one, but not both.
any further discussion?
Yeah, question. You know, it sounds like to me what we had here is he took a USPAP for the, 2010, 2012?
2012, 2013. Possibly.
2012, 2013, and then they came out with a new edition of USPAP, and he took the new edition of USPAP.
They came out with a new edition of USPAP in February of 2012.
Actually, this is all irrelevant. This is not pertaining to this question, so let's get it back on track here. Any other discussion regarding these courses? Okay, hearing none.
Can I have just one additional comment?
Yes, sir.
Would it be inappropriate to ask him if he had any content for the course that's in question? Would it be?
I did, and I've given you a copy of his email.
That's about halfway back in here is his response. This is his information he submitted, and he did not submit any information on the Louisiana real estate contracts when it appears. Is that correct, Dennis? All of this information.
He said he didn't have a timed outline, for example, so it was very difficult to figure out just how much we could or could not credit.
Oh, it's Texas that we're talking about
Yeah, the
here,
Texas
isn't it?
A&M is the one we're
Right.
talking about.
Okay. So say that again, I'm sorry.
He said he didn't have a timed outline, and I put copies of his email on there because I clearly explained to him that without a timed outline, it's incredibly difficult for the board to make a decision. And usually the board considers it incomplete as an application. He said, well, that's the best I've got. His email responses.
You're saying this is through the Texas A&M Real Estate Department?
No. This is Mr. Abbott.
But the provider, Dennis, is Texas A&M University.
That is correct, yes. The one we are denying. We've recommended denial.
Part of their real estate appraisal curriculum or just a real estate? I'm not sure I understand that.
It's just a real estate, it's a real estate legal course. And our rules clearly say that anything to do with, legal courses, especially from just
For real
brokers,
estate.
from a broker for real estate, not appraising for real estate, is to be denied. It's in our rules.
Business law, which is some of the content of the course.
A brokerage
License
flavor to
law,
it.
As opposed to, not real estate law, like.
That answer your question,
I
Gary?
think so, yes, sir.
Okay. Any other discussion? Hearing none, do I hear a motion?
I move that we accept the recommendations as proposed.
Motion to accept from Commissioner Point. Is there a second?
I'll second that.
Second from Collinsworth. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Excellent. Next item on the agenda is the,
Do we have a formal hearing?
it is the formal hearing. Is there a formal hearing? Okay, so there is no formal hearing. So the next item would be the legal report. Is our food here? It is? Okay, so what,
while we listen.
would the commission like to process the legal report as we munch on lunch?
We can.
Like to get a soda and whatnot.
Yeah.
Okay, so we'll go off the,
I have a quick question.
all right.
These formal hearings that were settled, do we have an idea what they were? Oh, okay, they were the
Those are
ones,
2 and 3
Okay.
of those 3.
okay, they were the ones that they had already, okay, I got you.
Okay, so we'll take a short break. We'll go off the record in order to get our lunch in front of us, and then we'll come back and we'll process the legal report as we enjoy a delicious and satisfying lunch. All right, we're reconvening the February 10th, 2014 Real Estate Appraiser Commission meeting. We are now to the point in our agenda where we are going to have the legal report. I've asked Ms. Baird to address the commission and to her best ability to summarize what the function of this legal report is. Why are we here and why do we do this? So.
Just to make sure that we're all on the same page, because I know a lot of times there are questions about probable cause and those types of things when we're going over the legal report. The function of the legal report really is to just determine whether we have enough proof, evidence, to keep it moving forward. That's basically kind of the bottom line. There's never going to be an instance on the legal report where you will be provided with all the information that we have, just because that would bias you if it were to go to a formal hearing. So the function of the legal report basically is to just determine if there's enough proof before you to allow the matter to go forward or to allow the respondent a chance to settle. Because when we send out a consent order, that's what we're asking them to do. We're saying, we found these violations, we're offering you this amount. If you want to settle, you sign this and send it back to us. If for whatever reason they don't want to do that, then it moves to a formal hearing if that's what you all authorize. If for some reason, while we're going through the legal report, you don't feel like there's enough evidence or proof in front of you, at this point, really the only option is to just either dismiss it. If you don't feel like there's enough there, then the best thing to do is just dismiss it at this point. So really, the function of the legal report, your only two options are you don't see enough in front of you, just dismiss. If you do see enough to have it move forward, then you need to decide whether or not you want to assess a civil penalty, or it could be that you see something there but you don't think it's enough to warrant discipline. So at that point, you would just close. I know that it can be frustrating sometimes to feel like you don't have all the information that you need, but I do assure you that I'm giving you everything that I can. I do try my best to get as much on there as possible and compile it in the best way that I can. So just keep that in mind as we're going forward. I know a lot of times you guys kind of feel like maybe what goes on in the reviewer's conclusions may not be giving you enough information, but these reviewers are the reviewers that the state's chosen. These are the people that we use, and like I said, if you feel like, there's not enough there, then you can just dismiss it. But I do assure you that I'm giving you all the information that I can. So just keep that in mind as we go forward.
Let me ask you some questions that keep coming up. Is it true or is it not true that the commission processes every complaint?
Yes, I would think that's a true statement.
Our purview, it is filed it to the wrong place, and then it would just be I don't know, contractors department, just because it wasn't you sent it to the wrong office.
Sure,
Then
but
it
I
wouldn't have
mean,
been processed in this, but even if it's, I think an appraiser, whatever.
right.
If an appraiser, if it's about an appraiser
So-
business.
And even
Goes
even
to-
if it's an appraiser complaint, and it does belong to the appraiser commission, but for whatever reason, under our statutes, we don't have jurisdiction to even discipline them on this specific complaint. For the most part, we still bring it before you all and say, here's the complaint, here's the response. However, we don't have jurisdiction over this, so that you're still seeing what's being filed out there. So even if we don't have jurisdiction, we don't just close and you never see it. It still comes before you.
I guess what I'm getting at, you do have an obligation. You open a file on nearly every case. You assign it to a reviewer. You interact with the respondent. And a USPAP review, USPAP compliance is assessed in every complaint if it's under our purview. Is that not correct?
If there's if the allegation is that they did an outlier type complaints where the appraiser let my dog out of the car, we didn't send that out for a reviewer. Those kind of things we don't send out for a review. Some things can be staff or administratively presented without having to be reviewed. But if there's an allegation and of an appraisal, it is reviewed, yes. Everyone.
When you prepare the legal report, it is only after you've gotten the reviewer's response and legal meets with Director Avers, and you formulate what you think the appropriate action is. That's the process?
Yes.
Okay, all right. And then it comes before this body. It's up to us to deliberate and discuss and decide if there's merit in this potentially moving forward to a settlement. They have the ability to offer a settlement. The respondent has the ability to negotiate. And last but not least, as we witnessed this morning, the respondent can negotiate a lesser settlement in avoiding a formal hearing. But the respondent always has the right and ability to have a formal hearing if they reject all else. And that's not even the end of it. So the legal report is not a be-all, end-all. It is just really the beginning. And I think it's okay for me to say this because I am a layman, but we need to understand what our role is in the legal report. So we won't get more facts. It would compromise the formal hearing. And by the same token, if we don't think that there's sufficient USPAT violations to justify what the team, if you will, has recommended, it's perfectly within our purview to change that, to lessen it, to strengthen it, whatever we'd like to do. But this is the first step, not the last. So, anything you'd like to add, either one of you?
I agree with that. You just have to keep in mind this is the first step. If we have enough proof to move forward. If you don't think you guys have the ability to just end it here.
And as peers, as appraisers to a large degree, no disrespect to our non-appraisal member, but as appraisers, do we feel it's appropriate? Commissioner Hall, I sense that you'd like to weigh
I
in.
just have a question. At this time, how many
Four or five at this point.
Complaints, and since non-residential is so very broad, we almost have to do a single contract every single.
I was wondering about is, Nicole, Keelan, do y'all kind of keep up with the review appraisers to make sure that we are consistent throughout the state with their reviews? Because if I'm in Nashville, for instance, and I'm reviewing reports here in this area, and I turn in what I feel are violations, and let's just go up to Knoxville and then to Memphis, covering the three areas here. Or my counterparts over there appear to be reviewing with the same degree as I would be doing here in Middle Tennessee? Or do you think it's a good idea occasionally to send out the same report to two different appraisers to get their feedback to see what kind of consistency we're getting across the state?
We don't. Hire reviewers, essentially. If they are not meeting the contract requirements, and there could be a variety of reasons, like timeliness requirements, just like an AMC would. aren't doing a good job, whatever, they aren't gonna be reviewing anymore.
What is the criteria for selecting a reviewer?
You issue an
Is it a number of years'
RFP?
experience?
I thought you issued a formal RFP and you took submissions. Is that not right?
Residential contracts, we had an RFP for those. Multiple different kinds of contracts.
That was for at one point, I think, when maybe Commissioner Point can talk to this, but at one point, they thought that we had enough demand that they could hire a contract reviewers in each grand division. So they put out an RFP, and then that person that won that contract became that reviewer. That was strictly on the residential side.
The situation, you have one residential for each grand division?
But, I mean, once we get a contract, if we're going along and we see that it's kind of not up to par, not up to standards, and we're not obligated to send them any certain number of reviews under their contract. So for whatever reason, we feel like it's not as it should be.
Certified general situation would just be a contract per review.
Not everybody's gonna meet the requirements to do that specific type of assignment.
This condemnation matter, I mean, we had a condemnation matter. Is it,
Those aren't an RFP, they're just, you just go call somebody up and.
Yes, we have to find somebody.
is it the will of the commission to talk to the review appraisers occasionally? Would it be informative to have a workshop, maybe at the beginning of each fiscal year, in which we basically, as the ruling body, we meet them? I don't think this would violate anything, would it? Why couldn't we have a one-day workshop or a 2-hour get-to-know-you thing in which we interact? And it would be, the commissioners can talk about whatever they feel is on their mind. It's informal.
Would that be a violation, Keeling, for us to know what review appraiser reviewed which report?
I didn't want to imply that. I wouldn't imply that we want to talk about cases or even
No, I'm
jurisdictions.
just wondering, though, when we review these legal reports, if, she,
Well,
I don't know.
I mean, we don't put the reviewer's name on the legal report for that reason. And, I mean, it is anonymous because it's done by numbers, and I try not to put any information in there about the actual area that these are coming from, so
I'd rather not know.
right. Well, I don't think that you probably should know. So I don't know if that would be a conflict. I don't really.
Viewers are.
I would not want to know.
If Eric was to review, I might have some concern.
Well, and to your point, Norman, I don't I think that the reviewer ought to be somewhat in that area and region. There are different conventions in Memphis than there are in the Tri-Cities.
Sure.
So I think that the reviewer should be, and I think it's a waste to have it re-reviewed a second time.
The one thing that if anything at all, the one thing I would like to see is what the qualifications are for the position. And as long as we're making sure those qualifications are met, then, then I think that would satisfy me. I wouldn't want to know who the individual reviewers are, even on an overall basis, but just to make sure that they're meeting the qualifications and those qualifications meet our standards possibly.
I remember correctly.
10 years.
Years.
Yeah.
Licenses in good standing, so.
Potentially or possibly, maybe it may need to be a requirement that they take the review classes, the TRIAC approved, because there's a residential review class and there is a commercial, the general review class. Maybe we need to make sure they've taken that course.
I'm going to throw this out, and then we'll move on unless someone else has something. But there has been, since I've been on the commission, there's always been a disconnect between commissioners and reviewers and the reviewers' comments. There's a disconnect there. Try this on for size. I submit this for your consideration. What if commissioners sent an email with these concerns to Ms. Avers, and then she passed it on to the reviewers? That way nobody knows anything, and when you have a comment, you have a concern, you have something that deeply moves you, you can email it to Ms. Avers, and she can send it to the reviewer. Now, would that work, Ms. Avers? It doesn't mean that they necessarily do anything different, but at least they would know what acting commissioners are feeling and dealing with.
Work for the legal counsel. That's their assignment. That's their client. Sometimes I read them. That doesn't necessarily mean I review them. I'm not reanalyzing their material. I'm not developing my own opinions on the quality of another reviewer's work, that kind of stuff.
A lot of times if I have a question, just because I'm not an appraiser,
Right.
I have questions about things that I don't understand. So a lot of effect of all of this, because I couldn't possibly even claim to understand all of that.
Go to
Record of
Nicole
me
initially,
reviewing
or do you?
reviewers.
Straight to
No.
me.
You discuss it, before you prepare the legal report, y'all get together and you discuss the review in order to arrive at your recommendation, don't you?
I mean, we discuss components of. I don't really discuss the review in detail. I don't want you guys to think that she reads. Ask her questions, and then I say, kind of, here's what I'm thinking. What do you think would be appropriate in this situation?
Right.
She's not, going through and marking it up, saying, hey, we need to do this, this, and this, because she can't do that.
Reviewing. Developing the recommendation.
Correctly, what happens is somebody files a complaint, they file it with the code, is that correct? Through our office, then you in turn give it to Keeling to write everybody, and do you write to the people and say a complaint has been filed, or do you send it to the reviewer? What's the sequence of events in this thing?
I have a complaint coordinator that works for my office. So when we received a complaint from whomever, and here's the complaint. Respond if you'd like. But you're required to send us your appraisal and work file. That's what the statute requires you to send the appraisal and work file. Encourage them strongly to respond.
At that point in time, then do you go over that with Keeling, or do you then send that out to a reviewer to go over it?
Once we receive a response, I mean, we give them 2 weeks. I mean, they could not respond, or they, whatever, we give them 2 weeks to
Sure.
respond. And
Okay.
once the response is received or not, it goes to process has gone to the legal department. It's in the legal department and outside of my hands and control until it gets.
At that point then, Keeling, you send it out to a review appraiser, correct? Then they respond to you with their review. And then, at that point, you go back to the appraiser and say, okay, this is what a reviewer found. What are your comments? Is that correct?
Right, because a lot of times the reviewers find something, I
Right.
guess, outside of what was actually in the complaint, so they have to have a second chance to respond to those allegations.
Most of the time, what we're doing here, if somebody complains that my neighborhood data is wrong, and we send, and it comes in, and then Keeling Nicole notifies the appraiser about this complaint, and then the person writes back and says whatever they're gonna say, and then it goes over to you. And then at that point, it goes to a reviewer who then can come back and try to find whatever else that might or might not be in the report that in their opinion does not meet USPAP. So they're going beyond what the original complaint was about.
Does the reviewer have the original complaint, or he just has a task to perform based on a USPAP review?
The reviewer has the entire work, the entire complaint file, so they get the complaint, the response, the work file, everything. The complaints, a vast majority of the time, are either from consumers or lenders or appraisal management companies, and the initial complaints, generally speaking, are the appraiser either appraised it too high or too low, and generally include some type of misleading comments. So that's usually the allegations. Your appraisal was too high and misleading, and in some variation thereof, they'll use different wording and whatnot, but that's usually the complaint. Your appraisal, this appraiser appraised my house too high or too low, and they used inappropriate. That's a typical complaint.
Let's wrap up our comments so we can move
Then the
forward.
reviewer, really, once he gets the appraisal report, he's got free rein, or she's got free rein, whatever the case may be, to find whatever they can with the report and not necessarily address what the complaint was actually about.
Well, let me address that. That's not the case.
I didn't say it was, I said it could be.
Well, I think in the majority of the cases, that's what original complaint.
As one would expect.
Yeah.
As one would expect. So,
I do think a lot of times too, though, that the reviewers try to address what was in the complaint as well.
Other states handle this the same way? I mean, just,
no.
Has to review the complaints that contain an appraisal for USPAP compliance. How they do it, states have different ways of interpreting, a lot of different ways, and Mr. Green can attest to this because he's talked to some of the states at different era
Just wouldn't
meetings.
believe it. We're cutting edge. I'm here to
Do you
tell
think
you.
your legal report doesn't contain
It's
Oh
information?
my
very,
gosh.
We're very streamlined compared to a
Oh.
lot of places.
And fair and unbiased and sanitized and,
The Working Real Estate magazine last week had a large article on this, about how each state is so different. They're not consistent. They don't conform.
all right, as is my duty, I'm going to bring this to a close, and let's launch into the legal report, please.
Okay. Item number 1, 2013017571. Complaint was filed by the attorney for complainant and alleged that respondent appraised the subject property with apparent errors, resulting in an inflated value opinion. Respondent sent a response to the complaint stating that it is his opinion that the data presented was a correct representation of the subject property appraised. I've listed the reviewer's conclusions there. I won't read those out loud unless you guys want me to do that. It's kind of up to you. The respondent did respond to the reviewer's conclusions, and that's listed next, and it's kind of a lengthy response. So I don't know if you want to take time to read that. If you want me to read any of it, it's up to you.
Read the complaint, and are you familiar with the allegations? Keeling, would you like to continue what?
The reviewer found that there was no support for the lot adjustments in the sales comparison approach and no opinion or summary of land value in the cost approach, which sets up concern that the sales comparison approach is overvalued. The reviewer also found that all the sales used in this appraisal are all from the same development, which is a violation of FNMA Freddie Mac guidelines in addition to all the other violations listed above. Respondent has been a certified residential appraiser for about 21 years with a rather extensive disciplinary history. The prior consent order from 2010 also included findings of overvaluing a lake property and failing to support site value and cost data. The disciplinary history, along with the violations found in the appraisal report, show a pattern of violation and should be considered as aggravating circumstances warranting 6-month suspension to be settled by consent order or formal hearing. Listed all of the disciplinary history just above that if you want to look at it.
Right. I'll try this a little different. I'll entertain a motion, or we can have a lively discussion. It's up to the commission, so. Commissioner Standifer, would you like to start? I have a motion to accept legal's recommendation. Do I hear a second?
Second.
I have a second by Commissioner Johnson. Is that correct? Okay, discussion. Commissioner Hall? Point? Commissioner Collinsworth?
None, ready for the vote.
Okay, all right. There being no further discussion, all those in favor say aye.
Aye.
Any opposed? Hearing none, motion passes.
Item number 2, 2013-017-581. This complaint was filed by the attorney for complainant and alleged that respondent appraised the subject property with errors which resulted in an inflated value opinion. Respondent sent a lengthy response to the complaint in addition to a lengthy response to the reviewer's conclusions, so it's all summarized in the response to the reviewer's conclusions section. The reviewer conclusions are listed there, as well as the respondent's response to those conclusions. So I'll give you a minute to read over that, and then we'll talk about the
Go ahead and continue, Ms. Baird.
The reviewer found the appraisal lacks research of the immediate and surrounding lake communities, sales, listings, lots, etc., and has possible violations of the ethics rule conduct section, which states must not advocate the cause or interest of any party or issue and must not perform an assignment in a grossly negligent manner. The reviewer also found that the subject's value is overstated by comparison of the other sales surveyed and retained in the work file for this review. All sales and listings used in the original appraisal were from the same subdivision and not a reflection of the lake community markets. Respondent has been a certified residential appraiser for almost 7 years, with one prior matter that was closed with a letter of warning specific to failing to support the site value and cost data included in the cost approach. USPAP deficiencies were identified in this complaint and the past complaint reviewed by a different reviewer, which seems to illustrate a pattern of deficiency in the cost approach. The review cited an ethics rule conduct section violation for overvaluation. As such, council recommends the authorization of a $2,500 civil penalty to be satisfied within 30 days of execution of the consent order, and a 15-hour residential site valuation and cost approach course to be completed within 180 days of execution of the order. Such terms are to be settled by consent order or formal hearing.
Okay, thank you. Commissioner Collinsworth, any comments?
I'm going to defer for the moment. I'm still reading through some of the other details. I apologize.
Anyone else?
Yes. Keeling, just a quick question. Excuse me. This 15-hour residential site valuation and cost approach, is that two different courses or one course with both items included?
My understanding is it's one course.
One course. It's one of the qualifying courses for residential appraisers.
Okay.
Okay, anyone else? Commissioner Stanifer?
It says the reviewer found the subject's value is overstated by comparison of other sales surveyed. Did he render an opinion of value? The reviewer?
Uh,
Opinion of values?
I'm still reading, to be honest with you, Mr. Stanford.
Just another question, a general question. I would assume that this reviewer had the record of this individual because he refers to a past complaint.
I think that's
It's something she noted.
That's our language, not the reviewers. Sorry, something's kind of tied in there together.
I think it's possible to look at the data and to say that the value appears to be overstated without estimating a value yourself. I think that's a point of contention in USPAP classes all over the country, perhaps, but that's my personal opinion.
That brings up another question.
Talk loudly.
Excuse me.
Oh, no, you're on.
There you go.
That worked.
Okay. I'm wondering, and I don't know the answer to this, so hopefully y'all can help me out on this. But the reviewer's conclusion, the Fannie Mae Freddie Mac requires use of at least one sale from different development and from a different builder. None of the sales used in the appraisal were from a different subdivision or builder. Is that a USPAP requirement, or is that a Fannie Mae Freddie Mac requirement?
I'd like to answer that one, if you don't mind.
I
That's
don't
the
know.
reason
I
that's the
don't
reason
know.
I deferred, Mr. Hall.
I don't know.
That's a Fannie Mae requirement. It is not a USPAP requirement, and that brings us back to our discussion earlier of I want to see what the qualifications are that these reviewers are reviewing under and how they became reviewers for the state, because I don't think they need to be picking on a Fannie Mae request, because if you refer to the follow-up by the appraiser, the respondent stated this doesn't even apply to this type of appraisal. He picks it out in his paragraph later and says it's not a Fannie Mae loan, so it wouldn't even apply. If you read the respondent's response, halfway through his paragraph, respondent stated that the aforementioned Fannie Mae requirements do not apply to this appraisal, and therefore there's been no violation of applicable rules and regulations. So that's why I want to make sure that our reviewers know what they're supposed to be reviewing for, necessarily. Not to say that the other items picked out may or may not be accurate or correct, but in this case, that did not even have merit to mention.
Form, and I think that's one of the requirements on the form. It's not?
No.
Okay.
Not at all. That's not a requirement at all. And that brings me to another point that I've seen in several of these reviews where they discuss highest and best use, and there's no reconciliation of highest and best use. Well, one of the certification items on that Fannie Mae form reconciles
Highest
the
and best
three
use.
approaches, I'm sorry, not highest and best use, but the three approaches, the reconciliation of the approaches. One of those certification items discusses that to a point. So I think our reviewers are missing that. That's just a side note in general.
But this is the proper forum to hear those comments. And,
Sure.
And that's critical, because this is what you do, and that's why your feedback's important. So, are there other comments? Or would someone make a motion?
I would like to make a motion that we place a civil penalty of $1,000 and require the residential site valuation and cost approach to be completed within 180 days of the order, not to be used as continuing education.
I'll second that.
Okay, so we have a motion and a second. Is there further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion passes. Did you catch the motion, Ms. Avers?
Got it.
Got it, okay. Thank you.
Item number 3, 2013-017791. This complaint was filed by a consumer and alleged that respondent undervalued a residential property by using inappropriate comparable sales data. In addition, the complaint also alleged that respondent did not consider in his value opinion improvements made by the owner which had a cost of $90,000. Respondent sent a response to the complaint stating she did perform an appraisal of the subject property and that she utilized the best comparable sales from within the subject subdivision and one additional sale from an outside competing development. Respondent stated she listed all upgrades that were provided to her from the owner and contractor. The owner feels that since she spent over $90,000 in upgrades, her home should be worth what she paid for it, plus the amount of upgrades she has put into the home. The subject was not considered to be similar to new construction and was not therefore considered any higher than a C3 rating. Respondent stated she took the amount of upgrades into great consideration and therefore the final value opinion was at the high end of the adjusted value range. The final value opinion was bracketed by all comparable sales utilized in the appraisal. An opinion of value is not based upon a list price or sales price. The respondent was also given the opportunity to respond to the reviewer's conclusions that are listed there. However, no response to those conclusions was received by this office. So I'll give you a minute to look over the reviewer conclusions and then we'll talk about the recommendation.
Go ahead, Ms. Baird.
Respondent has been a certified residential appraiser for almost 7 years with no prior disciplinary action. As such, council recommends closure of this matter with a letter of caution regarding the violations noted by the reviewer.
So move.
Motion second, any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion carries.
Number 4, 2013-019961. This complaint was filed by a consumer and alleged the undervaluing of a residential property by using inappropriate comparable sales data. Complainant alleged that the appraisal was unfair because the home was compared to 3 homes that were recently foreclosed. The reviewer conclusions are listed there. I didn't note a response by the respondent to the complaint or the reviewer's conclusions.
A comment in there, the reviewer says the appraiser did not complete the 1004 MC. Well, not all appraisals have a need for the 1004 MC, nor is it required.
I was
Nor
wondering
is it a good
that,
standard of measurement for anything out in the rural areas.
why would that, I guess, Ms. Avers, would you care to weigh in on that? Why would the reviewer cite that as a scope of work violation? Do you think, or do you know? Any clue?
I don't know. Off the top of my head, I don't really know. If it was part of the appraisal work file, it was included as a requirement in the engagement letter, but I really don't know. Redundant and not what, that's why we paid them.
Again, I sort of think they may be getting confused with USPAP versus Fannie Mae guidelines. And if this is a secondary market, as we were discussing previously, if this is a secondary market appraisal, and it's required by Fannie Mae, that's when you get into conditions of the client and therefore being a scope of work issue. However, we don't know that. So, again, we don't know the situation at hand. So if this wasn't a secondary market, that should not even been brought up.
One thing I would say is that all of the violations noted by the reviewers would be something that they would be testifying to if there was a formal hearing. So they would have to put on, well, the state puts on proof, but that's what the reviewer would be testifying to.
Right.
And they would have, generally speaking, exhibits. Ask them to make any allegations.
Here's a perfect example of what I was discussing previously about reconciliation. The last bullet of the reviewer's conclusions: reconciliation does not address the quality of quantity or quantity of data arriving at the final value. Adequate reasoning has not been provided in the sales comparison approach. Sufficient analysis, blah, blah, blah. From a reconciliation standpoint, one of the certification items says, I develop my opinion of value solely on the sales comparison approach and have enough information to be able to support it based on the sales comparison approach. I looked at the other approaches and did not develop them unless they were done so in the report, something along those lines. So, I mean, every Fannie Mae form appraisal has a reconciliation statement already in the certification.
And it typically has the highest and best use statement.
It does.
So both of those are covered. That's
Does
why it's
it-
a form.
Does that statement, I'm aware that a lot of those statements don't meet USPAP. Just because they're in there doesn't mean,
Well, USPAP says you have to reconcile the approaches, and if you leave an approach out, you have to tell why.
goes
You have to be
beyond
able
that,
to
though.
say,
It
you-
talks about the quantity and quality of the data and the strength of the approaches. It's not, USPAP requires more than a stock statement on a form typically.
But if your only approach developed is a sales comparison approach,
Then there's nothing to reconcile.
right?
Ms. Baird, did you conclude your presentation on this case?
I haven't gone over the recommendation yet.
Okay, please.
The reviewer found the inconsistencies throughout the report diminish the reliability of the report. The information provided and the opinions reported do not provide adequate support for the conclusions rendered. Respondent's been a certified residential appraiser for almost 18 years. He's been disciplined twice in the past. The respondent completed the terms of his last consent order in June of 2012. The subject appraisal has an effective date of July 1st, 2013. As such, council recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order, and 15 hours of residential report writing and case studies to be completed within 180 days of execution of the order, such terms to be settled by consent order or formal hearing.
Who'd like to begin?
I'd like to recommend, in light of the fact that some of the items mentioned by the reviewer is inconsistent with USPAP, $1,000 civil penalty be waived, and that will be required, or she be required, to take the 15-hour residential report writing and case studies to be completed within 180.
We have a motion to eliminate the penalty, but just require the class. Is that correct?
Yes.
Do I have a second?
Second.
Okay. Second from Commissioner Point. Is there discussion?
The first part of Mr. Hall's recommendation, just so I get it clearly, you said talking about items in this I'm sorry, I wasn't clear on that, so and I have to write
I
them.
just said that since Mr. Collinsworth pointed out that there were some obvious errors in the review, that in light of that, then I felt like maybe that the civil penalties should be dismissed, but do require the 15 hours of residential report writing and case studies.
There's-
Is he's just saying eliminate the civil penalty?
His,
And
his
stick with the
motion,
class.
his first part of his commentary was a comment.
Okay.
His motion was to eliminate the penalty and have the class.
Okay, I just want to make sure that.
Is that correct?
When Ms. Baird writes the
Sure.
consent order, she includes all of the bulleted items above. Okay, I'm just making sure.
Yeah, I mean, when the consent order. Bulleted items that are listed, even though you're just saying a class only, no penalty. It's not gonna, take out any of these. Okay.
I have a concern, to your point, Mr. Hall, and I don't want to beat this to death, but the reviewer had a reason to put in that first bullet. I mean, the reviewer was privy to the assignment and its requirements. And I can't help, we did not hear from the respondent. They were given an opportunity.
Right.
They
That's what
did
I'm
not
saying.
respond.
Yeah, so we don't know.
We don't know the situation at hand.
We
In
we
that
don't know, but
case-
the point of it is that 1004 MC form might not have even been required, and I don't know whether the reviewer knew that or not. So,
No, but
but
here's-
they're not required, then, but.
Here's my
Go-
point, Mr.
okay.
Hall. Here's my
Mhm.
point. The
Okay.
reviewer had that information, and the reviewer put the bullet in. The respondent had the ability to contest this review. He or she didn't. So we're kind of coming down on the side of the respondent when the respondent didn't even have the evidence to respond. So, I mean, in my opinion, the reviewer was paid to do his job or her job. They did it, and now we're ignoring it, especially in light of no response from the respondent.
Well, if you go to item number 2, bullet point number 2,
Yes, sir.
the market conditions addendum to the appraisal report was not completed. But we don't even know if it was required or not. So how can he say it wasn't completed when we don't even know it was required or not?
If you were going to be called to testify and you didn't have evidence that that was required, would you put it in your review?
If I thought that yes, I would, if I were not aware of the fact that I was not supposed to be gigging the person because something was not applicable to that appraisal report. In other words, if I was reviewing that appraisal report based on a Fannie Mae, a Freddie Mac, and that's not what it was, then I would be incorrect. And I'd have put it down there, but I'd be incorrect in putting it down.
So you'd prepare an incorrect review.
That's what it boiled down to, due to lack of knowledge.
Well, all I have is what the reviewer has told me. I have nothing from the respondent. So I would think that if it weren't required, the respondent would have said that.
Either that or the respondent said, well, if that reviewer is not aware of that, I don't know how in the world he ever got the job to be a reviewer.
Okay. Is there a further discussion? Okay, so we have a motion, we have a second. Let's take a vote. All those in favor say aye.
Aye.
Any opposed? Motion passes. All right.
Item number 5, 2013-020171. This complaint was filed by an appraiser and alleged that Respondent Appraisal Management Company engaged her to complete 4 appraisals in 2013. However, Respondent surrendered its registration as an AMC in November of 2012, thus Respondent was not registered at the time it engaged complainant for appraisal services. In addition, the complainant alleged that Respondent failed to pay for the 4 appraisals completed by complainant. Complainant included unpaid invoices in the complaint file as proof. Respondent controller sent a response to the complaint stating that it paid complainant in full for her services and apologized for the delay in payment. Respondent stated it originally requested the surrender of its license after its president resigned in August 2012. Respondent stated its AMC staff was informed that it was no longer licensed in Tennessee and therefore could not place any appraisal orders moving forward. A new president was hired in the fall of 2012, and unknown to respondent, controller, or owner, the AMC placed appraisal orders in the state of Tennessee. The new president has since resigned. As a result of the resignation of the second president, respondent ceased all operations as an AMC as of June 30th, 2013, and stated it will not be renewing its license or surety bond. There is proof of payment for complainant services in the file, and complainant did file a response saying that respondent has paid her in full with the exception of the late fees it owes her. Respondent has surrendered its AMC registration and informed us that it is no longer in business and has no intention of renewing its registration or surety bond in the future. Respondent did pay complainant for her services. However, respondent still practiced unregistered activity by engaging an appraiser in appraisal services during a time in which its registration was expired. As such, counsel recommends the authorization of a consent order for revocation of respondent's registration, such terms to be settled by consent order or formal hearing.
If we accept the recommendation.
A second.
Any discussion? Hearing none. All in favor say aye.
Aye.
Any opposed? None. Motion carries.
Item number 6, 2013-000831. This complaint was presented at the December 2013 meeting, during which the board voted to obtain an additional review from another reviewer and compare the findings. The following information is what was presented to the board at the December 2013 meeting. Do you want me to read this, or do you guys just want to? You've already seen it once. I just wanted to reiterate the information that you used to make your decision. So if you just want to take a minute to get reacquainted with this information, then I'll discuss the recommendation.
Ms. Baird, would you like to continue?
Respondent's license is inactive currently due to illness. He's already been disciplined, and the appraisal was done on December 31st, 2012. And this part that's listed here on the reasoning and recommendation, I think this was the original recommendation that I made, and then underneath it is where you guys voted to have an additional review done by a separate reviewer. So here's the issue. In lieu of the previously authorized recommendation by the board to obtain an additional review and compare the findings, it is the recommendation of counsel that the board make a recommendation based on the information that it has in the matter currently, rather than obtain the additional review. Obtaining another review would serve to complicate the litigation process if it were to move forward to that stage, and that it would place a burden on counsel and litigation counsel to have two different reviews for the same matter. The respondent may decline a settlement offer and in a formal hearing dispute the alleged violations. The state would present proof to the commission, including testimony of an expert witness, and then be called in the formal hearing to support the opinions and conclusions contained in their review. The commission, as the decider of fact in a formal hearing, has the authority to accept or reject testimony from witnesses. So what we're saying here is, in lieu of the recommendation that was made to get a different review, also do a review of this and compare them, what we're saying is it would be better to just make a recommendation based on the information that was presented to you in December, I think there's enough there to move forward, then we probably need to do a consent order. If you don't, we need to dismiss it, because if we have two conflicting reviews, if it were to get to Jesse in a formal hearing, I don't know how he would decipher between the two, and it's just gonna create major.
Ms. Avers, how do you suspend an inactive license?
Active is elective, suspension is not by choice. So it's a status.
So we take his inactive license and we suspend it so that when he gets done being inactive, he reactivates and goes right on? Or she?
Yeah, but the suspension is noted to it is discipline, and it's very serious discipline. So
We know
not
if-
making light of the discipline at all. A 30-day suspension is serious business, like,
know if they're still inactive.
they're still
Now.
inactive.
Okay.
And legitimately, he was very ill. So, but just separate issues. The appraisal report, while being sensitive to the fact that he's very ill, allegations in the complaints are very, very serious.
I mean, there were still violations noted by the reviewer, even though this person is.
Person is still ill.
Move we accept council's recommendations for authorization of a 30-day suspension to take effect immediately upon execution of the consent order.
Motion, do I hear a second?
I second.
Second from Commissioner Point. Discussion?
Yes.
Commissioner Hall?
The reason why I was objecting to this particular review goes back to what we were talking about earlier about the reviewers. The reviewer indicated in here that there was 62 sales in the year prior to the effective date between 20,000 and 650, with an average sales price of 189,184. Respondents reported the average as 110,000. Who knows who got what from when and where? I have no clue. But the thing that really, really bothered me is when the review appraiser steps in and says $10 per square foot for 1,181 square feet of garage space is low. Well, as a review appraiser, I don't believe we're supposed to do that unless we got support. And there is no support from the review appraiser to back him up on that. The range of the square foot for each sale is between $86 and $113 per square foot, yet the adjustment for size difference was made at $25 per square foot. Well, I think anybody who does residential appraisals know that when you divide the square footage into the sales price, it's going to be much higher than what you use for making a square foot adjustment for size. Now, if that reviewer don't even understand that principle, then we got a problem with that reviewer. And that was my concern about this whole thing. I'll go along with the recommendation that has been made by legal counsel, but I would strongly recommend that, Ms. Avers, you can contact this reviewer and ask them if they understand anything about residential appraising, if they're going to write somebody up on this basis. It would be an embarrassment to this commission to have that person come in here and testify that type of testimony.
Well, here's what's interesting and timely about this case is the prelude to our legal report talked about the process.
Mm-hmm.
And the counterpoint to your opinions is that the respondent was given the opportunity to respond. They didn't. They didn't. I mean, that's, you can comment on the quality of the review if you like, but the respondent, you know, the onus is on the respondent. When there's a complaint brought against you and you don't respond, good, bad, or otherwise, whatever the quality of the review, if you're not going to respond, then so be it. In looking forward, Tennessee's process is excellent because now, if the respondent still chooses not to respond, then it goes to a formal hearing, and we'll get to hear from this reviewer, and we'll get to see firsthand what kind of quality they do.
But then again, though, is it not if you're gonna come up with a difference of opinion or value as a reviewer, aren't you supposed to prepare a report yourself?
You only have a limited, I totally agree. However, this is not, you are not reading an appraisal review here, Mr. Hall. This is a legal report. So we don't know.
As an attorney, I probably might not have responded either and waited till I got this review on the stand to cross-examine him because I think they'd be made to look like they didn't know what they were talking about and the whole case would get thrown out.
So be it. However,
You know.
that is the process, and this is the process that we have. It's a good process, and if there's merit in this case, then we'll hear from the parties that are involved. So,
Fella's
This
sick,
is to
we're
get
gonna
the ball
suspend it.
rolling
indeed,
into that process.
yeah.
But I still think, though, if this appraiser commission chooses to ignore what we have been presented here from a review appraiser for our commission, we are in fact condoning what they did.
But you don't, here's the thing. I can sense that you think this review was horrible.
I do. No question about it.
And Ms. Baird, I mean, no disrespect to you. This is going to sound very disrespectful.
Fine. I'm pretty calm. It's fine.
These bullet points were prepared by our attorney. They were not prepared by the reviewer.
But they were
So
based on
you're
what the
not
reviewer
hearing,
did.
but you're not hearing from the reviewer. You're hearing from our attorney, and not our attorney, the state's, the commission's attorney. So, you know, don't read too much into these facts. You're not supposed to. This is show cause. At the hearing, that's when you get into what was the review and what did you find and what, you know, at that point, you're perfectly in line to say, how in the world are you making these statements?
Mr. Chairman.
Where's your proof?
I agree with you 100% on everything you've said. That still does not, in my opinion, excuse the review appraiser from making evidently comments in his report that would lead our legal counsel to put this in her report to us.
I would not hold the reviewer responsible. Not yet. Not yet. Seriously, not yet. Because this is like, what was the game? Post office? This is once removed. I mean, so, okay. Has there been a motion?
I moved.
Yeah.
You
to-
did to accept, and there's a second.
Ms.
We're still
Points.
discussing. Is there more discussion? Thank you. Commissioner Stanifer?
Ask for another review? Was that Mr. Hall?
No, I think it was Commissioner Johnstone.
It was based roughly
A
on.
hardship if this goes forward for the,
Yeah, because I don't know how litigation would even.
not throw out,
Between the two,
if
I
you've
think.
got two reviews, can you not throw out one under attorney-client privilege and just not even recognize it or not?
Opposing legal
Well,
gets to,
Well, and the attorney himself would be the person making that decision, and he's not an appraiser, so that kind of creates, how is he gonna decide?
Not like in civil law, it essentially, once it gets to formal hearing, it becomes discoverable. Potentially, everything that is not.
Even the review.
Except for communications between me and legal counsel.
my reason for making the motion is based on this appraiser's previous disciplinary history and the fact that they chose not to respond. That's going to get the ball rolling. And based on their feelings, which we don't know, they'll either accept the 30-day suspension or they'll say, I want to go to a formal hearing on this. And they'll provide information at that time.
Or we have, in the past, we have even considered, I'm so ill, I need some time, I need to defer this. That could be the case too here. I don't want to read too much into it, but the process is a good one. I believe in the process, and they have an opportunity here. Go ahead, Commissioner Hall.
No, I'm
Oh.
all for it. I
Okay.
said, let's move forward.
Okay.
However, I still go back to comments that Mr. Collinsworth has made, I've made, and some others have made about the review appraisers who are reviewing this stuff. We need to make sure they're competent to be doing what they're doing. And when I see comments like that, it brings it into question. That was the
Proper
whole
juncture, we'll find out how competent they are.
point. I hope so.
Any other discussion? Hearing none. All in favor of the motion, say aye.
Aye.
Any opposed? No opposition, motion carries. Thank you. The motion was to accept council's recommendation.
Okay, we're good.
Can I just get a clarification on one thing? Excuse me. So the only attorney-client privilege is between you and legal counsel,
Or Jesse, yeah.
but not the reviewer?
Well, when they,
Right,
to
until,
the point
until the
where-
formal hearing, and then it's discoverable.
yeah.
At the formal hearing?
Not until then. So even if,
So even if you had two reviews, he wouldn't even know it until a formal hearing, is that correct?
who wouldn't know it?
The other side in this case.
Well, this minutes is of record. It's
Right. And we would have to send out the review for their response, so they would know, because they would be responding to two different reviews.
We should do the right thing every time. So I am not for, personally, ever back and saying, I think, like if it's either cool or it's not cool. Like that's my opinion on it. Not to put too slang on it. It's like it's either a good review or it's a bad review. Vote it up or vote it down. I'm not gonna get invested behind like whichever reviewer this was. I don't even remember which reviewer it was. If you don't like it, vote it up.
I mean, it's difficult. I mean, you can't really, it's kind of like your form shopping.
Well,
Shop
I
around
think
to
there's a
see which
broader
one.
issue than just vote it up or vote it down. I think it's a real legal issue. Not as a lawyer, but just as an appraiser. I work on a lot of cases, and there may be 3 or 4 appraisers, and they only use one, and nobody ever knows about the other 2. So this is new to me, that you can't have 2 reviews. It just seems like we work on stuff all the time where there's several appraisals. We're used to that.
But you both could testify in formal hearings, and you both may have the same opinion on something, but you may not say it in the same way. Or you may have an opinion, but you wouldn't want, maybe you have differing opinions, and you wouldn't necessarily want Ms. Point telling you you were wrong, your opinion is wrong, so go back and, this is their opinion, they're going to support it, they're the appraiser that communicated this opinion. If their opinion is wrong, you're entitled to your own opinion on it, but
If you respect the process, if we respect the process, this comes out in the wash, comes out in the formal hearing. So if this, and that's I guess that's my point, Mr. Hall, is if this is a terrible review, terrible reviewer, it comes out in the hearing. And if this is a good review and you've just gotten a very condensed communication, then you compromise the state's case by having it reviewed and a second opinion tendered.
I understand, and, whatever this commission wants to do, I'll go with it. However, if I were ever to do an appraisal and I find out that this was a review on here, you can bet I'd go to a formal, because I'd eat that lunch.
And we would embrace your ability to do so.
We just gave them the option to be able to do that.
Correct. Precisely.
Because, this is just so It's just blows my mind that we'd even accept something of this nature, but that's beyond the point. The point of it is, we need to move on and make a recommendation for this person, and I voted for the recommendation of council.
There we go. Let's move to the next case.
Okay, item number 7, 2013022991. This complaint was filed by a consumer and alleged that respondent undervalued a residential property and did not visit the property. Complainant alleged that respondent appraised it by using photos from MLS, and there are no comparable sales listed in the appraisal report. Respondent responded to the complaint by sending a copy of his work file report and documentation that the office requested. The matter was sent to an expert reviewer, and the reviewer found that the subject of this review was intended to be an evaluation and not an appraisal report. The reviewer stated that it is written by a state licensed appraiser who states in the comments, under purpose of report, that this is not an appraisal. Also, as stated in the purpose of report section, it is the purpose of this real estate inspection report to provide basic information concerning the subject property that is being taken by the lender as collateral. The inspection will provide information needed by the lender to make a prudent loan-making decision. TCA 6239104D allows evaluations under certain circumstances and does not prevent state licensed appraisers from performing the evaluation. The specific language of 6239104D is as follows. This chapter does not apply to any evaluation of the value of real estate serving as collateral for a loan made by a federally regulated financial institution or to any evaluation of the value of the assets of a trust held by the institution, provided that the evaluation shall be labeled on its face, this is not an appraisal. The reviewer in this matter expressed concern that the code states that the evaluation must be labeled on its face, this is not an appraisal. A statement to this effect is made in the report under review, but it is in sentence format in the comments section and is not in a label format as required by the code. Council recommends that since the respondent did indicate that this assignment was not an appraisal within the report itself, respondent has taken the proper steps as identified by the code and thus falls under the exemption language in the statute. Respondent has been a licensed real estate appraiser for almost 20 years with no prior disciplinary action. As such, council recommends this matter be closed with no further action.
So move.
I second.
I'd like to discuss, just
Please.
to let you guys know ahead of time, because of the new regulatory changes that have been brought about by the co-evaluations rule. I foresee that we're going to start seeing this a lot, because going forward after January 17th of this year, borrowers, applicants will get a copy. They must receive a copy of the appraisal or the evaluation, even if the loan doesn't close on a dwelling. So I've got a feeling going forward, more and more borrowers are going to be given copies of evaluations that they may have problems with, and they may be very well sending them over to file a complaint on an evaluation and not an appraisal. So I don't know if there's anything we can do ahead of time other than just prepare you guys, but I see that it may be coming. Yep.
Other discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion passes.
Item number 8, 2013002801. This complaint was filed by a consumer and alleged that respondent undervalued a residential property. This consumer had his property appraised several times since purchase. He included with his complaint the last 2 appraisals and the appraisal review, which contained an opinion of value he felt was inappropriately low. The original appraiser estimated the property value at $285,000, and the review appraiser estimated the property value at $157,000. The subject property is a rural residential property with a lake view, but not lake access. The complaint file contained the original appraiser's rebuttal letters and explanations, and the respondent review appraiser responses. The respondent communicated a standard 3 appraisal, which contained an opinion of value, so therefore it also had to comply with standard rules 1 and 2 of USPAP. Respondent sent a response to the complaint stating that, as it was stated in the report, the field review is based on an exterior inspection of the subject property from the street and per information from public and or MLS records and other information available to a respondent as of the effective appraisal review date. Also stated in respondent's report, Any value indicated by respondent as the review appraiser was not based on an actual interior inspection of the subject property, which could have a positive or negative impact on the subject's current estimated market value. Since verification and lack of information was provided to respondent as the review appraiser, her conclusions were based on an assumption that the subject was in average condition. Respondent stated she included additional comparable sales that were available as of the effective date for the client to consider because the original sales utilized were not the best indicators of value. Respondent stated the original comparable sales did not have water views, as did the subject, so they were not the best indicators of value. Respondent stated that she noted in the report that any value indicated by the review appraiser is not based on an actual interior inspection of the property, which could have a positive or negative impact on marketability as well as value of the subject property. Although the reports had very different value opinions, the development of the opinions were essentially the same process and had the same data pool. The choice on which sales were comparable to these appraisers came down to what each determined were the relevant characteristics of the subject property. The original appraiser selected based on lake access and lake view and amenities. The respondent review appraiser selected based on proximity and size. The review appraisal was subject to the extraordinary assumption of the condition being average. It appeared from the complainant comments that there have been many improvements that exceeded average, but the reviewer could not have reasonably been expected to know this performing an exterior-only appraisal. Both appraisals, given the context of intended use and intended user, appear to have been developed and reported credibly. Based on the above comments, it is the recommendation of staff and council that this matter be closed with no further action.
Second.
Okay, my turn. I guess I have a problem with that conclusion. I mean, the reviewer's rendering an opinion of value. How do you waive all these things? How do you waive the inspection, and how do you... Some of it's nonsensical to me. Respondent is the reviewer, correct?
Yes.
So the respondent stated that the original comps did not have water views, as did the subject. So the subject had water views. They were not the best indicators of value. So the subject had water views. The original comps did not have water views, but yet the value's lower? Was it just a really bad water view? Was it a view of yuck? I mean, we don't know, that we don't have the facts. I just, the complaint was filed by the consumer. The reviewer drastically cut the price, or the value, I should say, and it looks like they did it in a fairly, in my opinion, lackadaisical manner. It's, yeah, I'm not, I think closed with no further action is kind of light duty here. Discussion?
I'm kind of curious as to, so like you said, the respondent is the review appraiser in this
Correct.
case.
And came in with the low value.
And then, so we did not have, that was not a state review appraiser. It was just a reviewer, a field review, I guess you would say, that maybe the borrower's lender had completed.
Mm-hmm.
So we did not, the state did not have a reviewer review either one of those. Is that correct? Right.
Our goal, I don't mean to cut you off,
No,
Mr.
you're fine.
Collinsworth, but our goal is to protect the public, and I don't see a letter of caution protecting the public from this reviewer if this is the kind of reviews they're going to do.
We have to accept what they have.
No, we don't.
Oh, yes, we
only
do.
for show
It's only
cause.
for show cause.
No.
No,
You
you
can-
have to go, over here, we got review appraisers, who I didn't
We
think
could
know what
ask
they
for
were
a,
doing.
we could ask
Over
for a
here,
state
you got,
review. We could increase the penalty, or we could eliminate, we could not even send the letter. We could even send a commendation and say, you need to do more of these reviews.
I agree. I think we should.
Well, I mean, I am just sort of curious on this one as to why we didn't, is there a reason why we didn't have the state do a review on either one of these?
There are a lot of instances where recently, I'm gonna try to explain this the best I can. We don't have a reviewer, I guess, in a certain area, and it's taken us a really long time to find somebody, to the point where these are just getting ridiculously old, and there are still several sitting out there that are still sitting out there because we have no one.
Okay.
So, I mean, I don't know if that answers your question. I don't
Lack of competent reviewer for that area,
have anybody.
basically.
I mean,
Mr.
there's,
Standifer, you had a question.
It's not just a question, I think it's just a comment. Based on my conversation with our litigation counsel, it's my understanding, and you guys can weigh in on this if you have a different understanding, is that anything short of a formal hearing is just a show cause situation. And according to Mr. Joseph, they're not going to show their full hand at that point. So all we're ever going to get is their summary of it, and they're going to keep, they're going to keep their file to themselves in case it goes forward to a formal hearing. So I think we either have to accept this and move with counsel's recommendations, or possibly go to another type system. I think that's just where we're at, because we're always going to be able to question these reviews, and you have a lawyer that's writing a review of an appraisal, so it's just, you're just going to have situations where you have this come up over and over. I'm not sure what the way the system is now. We're not going to have the information, and we're always going to have questions, because that's just the way the system is. Is that inaccurate?
Was there not a review, or I see there's no mention, it says in here there were 2 appraisals and the appraisal review, but I don't see any mention of the other appraisal. Was that ever reviewed? Well, it says in here the consumer had his property appraised several times since purchase. He included with his complaint the last 2 appraisals and the appraisal review, but it only discusses one appraisal at $285 and a review at $157. So I don't see any other discussion of the other appraisal.
you're
in there.
correct.
Okay. Was there a reason why that one wasn't? Was it just because there was no review of it done? I'm assuming usually the reason you have a review is because you got an appraisal. So that one appraisal at $285 was then reviewed at $157.
Right.
So you don't have anything out there for the other appraisal.
Right.
So
'Cause
I
it
guess
wasn't-
maybe instead of having it reviewed, you just, okay. Okay.
Call for the question.
Okay, is there a second to call for the question? All right, hearing none, we can discuss further. It's my point that the council's recommendation is too lenient. That's my point. So if it's the will of my fellow commissioners that it's ample, then so be it.
But I don't think you have all the facts.
You don't have enough to make anything.
I mean,
You
yes,
gotta
it's
accept it.
difficult to make that decision based on the system when it's just primarily a show cause.
How old is this appraisal? Do we know? Can you tell us?
I do not know. I can check. I don't have it with me, but
I don't see any dates in here, was why I was.
Nicole, do you
Well,
have any idea?
I have enough facts to form an opinion personally. And my opinion is, and I'm just sharing this, the review appraiser didn't go inside the house. They,
Could have been an exterior only.
It was.
it was, and it was stated that way. But my point is, be very careful putting a point value estimate on something when you can't even go inside the house.
That happens quite often in
Yes, it does.
foreclosures, especially HUD, VA, Fannie
happens
Mae
all the time.
foreclosures, that you can't get in, they'd shoot you.
Okay, so,
Case, did you have,
And not only that, I've known cases where appraisers have been asked to do a drive-by appraisal and never went in the house and just had to base it on the best they had. And the best comps they had sometimes didn't come up to the same value that was on one, but somebody went in. That doesn't mean they're a bad person, that don't mean they're bad appraisal, but they
That was
tell them right
the
up front.
scope of the work.
Yeah. Mm-hmm.
I understand.
exterior
So
only.
if I'm the consumer here and my loan's killed and I don't get my new loan, and it's because a review appraiser looked at my house, didn't go inside, stamped a value on it, that's okay. I mean, I understand that's the process and that's the protocol, but there's some other inconsistencies here, and I think it might even warrant having the state have this appraisal and the appraisal review reviewed.
Well,
And I'm done, I've stated my opinion.
My concern.
let's call for the vote.
There more discussion? Okay,
Remove my second from the motion.
absolutely. We hadn't voted on it yet.
Okay.
Okay,
Withdraw my second.
okay, all right.
I'll keep a motion.
So the motion's on the floor to accept council's recommendation. Is there a second?
second?
We have a second. Is there any further discussion? All right, hearing none. Let's vote on this motion. All in favor say aye.
Aye.
2 ayes. All opposed?
Nay.
3 opposed.
Abstain.
Ms. Point abstains. All right, so 3 opposed, motion fails. All right, do I hear a new motion? And I don't think it's appropriate for the chair to make a motion.
I move we have these reviewed, the appraisal and the appraisal review. My only concern making that motion is in regards to how competent a state reviewer will be. Is this a situation to where we're going to have to contract out to someone independently because of the location of this property?
Probably, yes. I mean, there's just no one.
Is it remote? Up in my area? Probably
You
so.
can't know that.
I don't care where it is.
Can you make any comments on this?
That was about it.
That was it.
Well, why don't you go to the nearest state reviewer and ask them to try to find a competent reviewer? I think that would be a good start. And then you might go to former commissioners. That would be another good start, because they know this process.
It's probably just gonna be, I mean, if we were to go with this. Just to be clear, this just proposing that this incorporate not filed against, just an appraisal we received. We're gonna have reviewed because a consumer included it in audit.
So are they,
There was no complaint
are,
extra filed.
wait a minute, let me ask you a question.
Yeah, the complaint was against the reviewer.
Was against the reviewer, is that what you're saying?
Correct.
Right, but if you want them,
I see what you're saying.
are you
I'm gonna-
proposing that we review now a file, a report that was not
That's
complained
helpful.
about?
I see what you're saying.
Like.
I'm gonna
like
withdraw
some
that
guy
motion.
Who has never, some person who has not received a complaint, all of a sudden is going to get a state. Surprise!
Thank you. Commissioner
That might
Collinsworth.
freak them out a little.
I'm gonna remove that motion and,
The first time
Oh, I see your,
administration
I
is
see your
offering
point
it.
now that, yeah, right. The respondent, the only respondent in this is the reviewer. I,
Oh, your motion, Commissioner Collinsworth, will you second? There
was no second.
there was no second?
no.
I'll go back and make my original motion, and that we accept council's recommendation.
Is there a second?
Second.
Is there further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed?
Aye.
I'll oppose as well. So, motion carries.
There's one final item.
Have some discussion about that, just.
Oh, sure. Okay,
For the last one.
okay.
Please.
already voted.
No, from
No,
the
there's,
next one.
there's one more.
Oh, number 9.
Well, the proper thing would have
Trouble
been here
saying.
to have reviewed the review. The state could have reviewed the review. Is that correct?
There would have been no context.
There would have been no, that's the,
I would have become the complaining party.
exactly. The,
That would have been an overreach, really.
Well, if you review the original appraisal, it would have been an overreach, yeah.
I could do it, but I would have had to have,
I appreciate you bringing that to light. I wasn't considering that
I
because,
wasn't
I
either.
mean,
I wasn't either.
clearly though,
Let's move on. Item number 9.
Item number 9, 2013023431. This complaint was filed by an appraisal management company and alleged that respondent lacked consistency throughout the report, manipulated numbers, and used sales outside the county when similar sales were available. Complainant alleged that this information affected the credibility of the report and the stated value. The only response to the complaint received from respondent was a copy of the appraisal report. Respondent requested an extension of time to submit the response and the work file, however, respondent never submitted the work file. It should be noted that respondent let her license expire and it has been expired since October 4th, 2013. Her grace period to renew will end April 4th, 2014. Respondent is 87 years old and has never had any other complaints filed against her. She does not hold a credential anywhere else in the country. In her brief response to the complaint, respondent stated that she retired earlier in 2013. She strongly disagrees with the complainant's comments. Due to the mitigating circumstances surrounding this complaint matter and the fact that respondent has stated that she is retired and her license expired in October of 2013, council recommends this matter be closed with no further action.
Second.
Any discussion? Hearing none, all in favor say aye.
Aye.
Opposed? Unopposed. Motion carries. All right. Any further business, commissioners?
I would like at some point though, possibly next time, us to discuss more about getting a better understanding of the requirements on the reviewers, the review appraisers.
Would you like to see a copy of the RFP? Wouldn't that be a start? I received a copy. It was sent in a broadcast of some sort. Maybe it was
it was a
before I was.
long time ago. I don't know if it,
Back in 2012, I guess, wasn't it, or was?
yeah. I could probably show you at least the salient points of the RFP. I don't know if because it's already been an approved contract, I don't know if the RFP would be available as opposed to already approved.
You want to see the qualifications?
I just, I'd like to see what the requirements are for that position, and see if we may need to make some modification to that as a whole, if possible.
I get that. I get that.
Sure. Yeah, if it's separated, the residential's the one I'm concerned about.
If we don't have requirements for the reviewers, maybe we should. I mean, some of our most contentious conversations are how competent they are. Maybe we should draw up qualifications for these folks, realizing that maybe we have a weighted scale. Maybe they're not equally weighted or something, but, you get so many points for this, that, and the other.
Does legal counsel review and grade their,
They don't have a basis to grade it off of, to my knowledge. I don't see how you would. Still have to be competent to submit the bid, and you have to meet those qualifications supposedly.
There's different kinds of contracts. One of them, I can't remember what it's called, but one of them is a criteria based where you rate by points. Cost based RFP where it's lowest bid, but you still have to meet minimum criteria for that. But it's like anyone who whoever has the lowest bid wins. That's the residential ones. Like I said, it was
discourage the low bid system personally, but.
Absolutely.
Well, cost is a key factor, in the state's budget.
On the one
But-
hand,
but it-
yes, you may
but-
save
but-
$300 in a review.
But if you consider the fact that in order to submit the bid in the first place, you're supposed to meet these levels. So once you've met those levels, it's up to you if you want to submit the lowest bid. Hey, I'm just as competent as these other three guys, but I'm going to do my work for a lower amount because I need the work more than these guys. That's what they're supposed to be saying, but that's why I'd like to see what those requirements are.
I would agree with Chairman Green that. Also, I'd like to request at the next meeting, if possible, that we have an explanation and maybe an educational session with regard to the legal process. I know Jesse went over it with me there at break, but I think it would be beneficial for me again to hear it, but also so that we understand our role as was explained to me, and the show calls and the implications of what that means and what you guys are doing, and help us to understand the large picture.
I know legal counsel. Sunshine law, so. Maybe
That's not this.
I know, but
Oh.
they maybe incorporate a couple other.
And that would be good, but even if that's not going to happen at the next meeting, if we could get a session that deals with this, it would be good. Because I think there seems to be a lot of apprehension about the reviews, and we just don't know. And then we catch feedback from our peers with regard to what happens down here. So, we're under that pressure as well. So we just want to understand the system, understand the role of everyone, and understand it.
Is it possible, does Arrow have a forum that you could ask other states what their reviewer criteria is? I mean, we might be able to look at other states and what they do to choose their reviewers.
There's a discussion forum on the Arrow website. Onto it.
If you could,
I don't want to talk it down, but it
No.
just, at a certain point, I had to unsubscribe to it because it was starting to drive me crazy.
well,
Yeah.
even to the point where if you would have Iman or Dennis or one of your staffers poll other execs that you respect, that might be even better. Just, I met Mr. Disney. I would be curious as to what the leading edge reviewer criteria is. Not that ours is not.
It's
but-
evolving too,
Sure.
because Kentucky used to contract out their work just like we do. And they now have just hired a full-time staff contractor. But as big as Kentucky is, they have like now one guy to do the entire state, so, and, yeah. So,
That's crazy.
you know, I don't know.
Yep.
Imagine that for Tennessee? I mean,
No.
I don't know.
How
I don't
many-
know if there's a one-size-fits-all for every state.
Cases do we usually process each month? Any idea?
Open, I think, 45 to 50 any given month. So that's a lot of moving parts, and that's just one board too, so.
Appraisals for one person that's an awful lot. I don't see how they can do it. I really don't.
Some years we've had higher numbers, like one year we had over 100 complaints one year. So. I actually thought that this was gonna
Breakdown on those are
be a
residential.
high year, but it turned out that it wasn't.
What percentage of those were residential, commercial, roughly?
Probably 99 to 1.
There's been a lot more commercial than I thought there would be. I would say it's closer to 90 to 1, or 90 to 10, but we've had a bunch of commercial.
It seems like lately we've been having fun.
It's tipping back the other way.
And with these evaluations coming about, I think you're going to start getting a lot more evaluations turned in. I'm going to have to throw out, basically, but
And know that I'm throwing everything else into the non-residential pot. So that's, you know, 5-plex, anything over 1 to 4 family, I'm throwing into residential, farms, everything. Hard because you know, the RFP that you were talking about for the residential, you can say residential in a certain area. Non-residential, it's easy to like to think, let's just get a contract, but like, could any of you say you could appraise any type of non-residential property? It's like, no, that's crazy.
I know a couple guys that would say that
Say they
could.
would?
You know, somebody thinks they can, right?
Okay, well, so we are meeting in March, correct?
I believe so. Although I'd like to think about maybe, this is a intensive year coming up. I'd like to, though, in 2015, start thinking about maybe doing it.
Well,
Start with March.
well, we got a lot of change
Rulemaking?
coming down January 1.
Rulemaking and
So even if our agenda is light for March, I think we still ought to meet and deal with these rulemaking issues
pre-arrow.
that I want. Yeah,
Meeting and all.
pre-arrow and, so we are meeting in March.
And I'll come up with a definition for good standing and compare that.
That would be straight standing. Sorry. Is there a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
All right, we're adjourned.
Hey, Eric,
Yes, sir.
I appraised that office building right